person who's dead. That person died as a result of multiple gunshot wounds, showing that the firearm that he had at the time when he was firing the shots killed the deceased. So the only inference is that firearm was in a working condition, insofar as it complies with the Firearm Controls Act. Those are the proven facts. What other inference can the court draw? Only one. At the time when you fired the shots, in view of the fact that you are not in possession of a firearm license, that firearm, regardless whether it's recovered or not, that firearm on that day, at that specific moment, you were not in lawful possession thereof. That is inferential reason. That is what Gabashe is saying. Putting it into our facts here, we have evidence of 2 firearms that were used. We have recovered one, we have not recovered the other. But on inferential reasoning, we will say the second firearm, because it killed the second deceased. And the person who will be alleged to be the person carrying that firearm doesn't have a license to possess that firearm. The second person killed the first deceased. Which firearm we found on accused number 3's possession? He does not have a firearm for that license. Neither the person we're alleging fired the shot has a firearm license for that specific firearm, because we have it to say that even the serial numbers were fired off. Those will be the proven facts during trial, which will then show that at that time, those 2 firearms were not lawfully possessed. We then jump to joint possession. But this is all the worship for the trial court to decide. It's just to highlight why we're saying there is case law supporting conviction in this kind of cases. Exhibit G explains clearly that there was an arrangement for people to go and collect the tools, if I can use that loose word. Which tools were going to be used to kill the deceased? In particular, deceased number 1. Those tools were indeed used. We've got a CCTV footage showing people firing shots at that crowd. The 2 deceased died as a result. We're saying the evidence shows that the tools were brought back to the persons who gave it in the first place. Hence, in April, it was found in possession of accused number 3. We have evidence that says he made arrangement for it to be given to the co-accused and those that are in Swaziland, used at wish, brought back. Therefore, the trial court will have to decide whether the first and the second requirements of the joint possession in this instance is applicable. But that is for the trial court. But prima facie, everybody knew we are going to Umlazi to collect the firearms that we are going to use to kill the deceased, because we have been contracted to kill the deceased. Whoever has it will have to collect it, have it on our behalf. Use it, kill the deceased on our behalf. Therefore, we'll take it back. That is for the trial court to decide, but prima facie, the evidence so provided proves joint possession. Therefore, it's our submission that the submission by my learned friend that because there might be duplication of charges and the charges might not be proved by the evidence, lacks merit and should be dismissed. Delays. If one understands the words of Judge Snyders, who I happen to have appeared before whilst I was still in the Johannesburg court, is that after the arrest, the undue delay might cause or might be taken into consideration so far as bail is concerned. Warrant Officer Pillay is clear on Exhibit G and G1. We took time to investigate this matter, up to an extent that when the matter was at an advanced stage of the of the investigations, we took a decision to arrest. Naturally or consequentially, when persons are arrested, certain evidence comes up, for example, during the bail applications. Even though we are saying, as indicated in Exhibit G, that we're still following the money and other monies and all of that, we have indicated that what is it, but we are at an advanced stage. That may lead to certain arrests of certain people, but we should not lose sight of the fact that during the bail application itself, certain evidence crops up. Which evidence one must follow? I will make an example. We have alleged that during our investigation, we did not find any form, in whatever manner, of evidence supporting the payment of 800,000 to applicant number 4. We have not found it. We are told, I'm still going to argue that point at later stage. We are told that it's a business transaction, nothing more. But I'll argue that later. What kind of business transaction? What is that to date? We've investigated that. We said we cannot find anything. Now, somebody says something during the bail application. Statements are being brought from certain people who are not even accused before that, brought into the fore. The point I'm trying to make, Your Worship, is it is a known fact that a matter is investigated up to the judgment stage, because things do crop up. But all we are saying is, insofar as to try not to delay these proceedings, the state took its time to investigate. Your Worship can see the amount of evidence, the analysis and everything that has been done by the investigating team up to this fact. Therefore, the issue of the delay should not be seen as per Snyder's judgment, because Snyder says you immediately arrested and now you want to prolong. We did not do that. We first investigated, arrested, and then we are not going to prolong the investigations because we have done most of it before the arrest. So
the concern that has been raised is that after judgment in this matter cannot be sent to the High Court or to the forum where it will be held.
Definitely, Your Worship. As I said, we never fold our arms and said we're done. We said there's some monies that we need to follow, of other monies except this one. There are monies that we're going to follow. We do an analysis of that, and on top of that, there's evidence in this bail application. We do not want to find ourselves at trial to say, but we never followed up, but we told you during the bail application, this is the situation. But is that going to be prolonged? No.
But are you in a position to give us an indication, more or less, how long the remaining or the outstanding investigation is going to take?
Your Worship, we are at the stage where we can say, at least from now we are in May, by the 4th or 5th month from today, we will be in a position to say we can set a track date. 4 to 5 months from now, basically. May I just approach you? Now, which brings me to the issue of extradition. Your Worship, it is and must be understood that the DPP KZN has made a request in another country to bring those, to arrest those and bring those back to South Africa. as soon as it can possibly be. It's a request. If that request takes its nature to, as there were certain submissions here, 2 years or 3 years or whatever the case may be, which we doubt is going to be like that. At some stage, we'll have to make a decision about this trial, about the 4 that we have or any other that might be added, and not be bound by the fact that we still have to wait for that request to be finalized. At some stage, a decision will be made. There will be objections, for example. We make an application in court and say, can you give us 2 months, this will be finalized. That court will deal with that application at that stage. Should that court find that it will be a delay, we will proceed with the matter with those that we have arrested.
So am I understanding you to say that the trial may proceed against the present applicant before court in the absence of the 2 that are in Swaziland?
If that is the eventuality that should happen, it will happen. That's basically what we're saying. All we're saying, Your Worship, is we wish for our request to be attended to as soon as possible. Should it happen that you come to a stage where this matter has to be set down for trial and the request is not yet finalized, we will proceed with those that are here and deal with those 2 as and when the time comes. A request, of course, will be made for whatever. Every time a matter is brought before court, many applications are brought. The presiding officer of the court sitting will deal with that application as and when. It is our wish, and we are of the view that it will be done not longer than 6 months. That is what we have. That is the information that we have. Therefore, as and when that time comes, we will have to make a decision to say, we would have loved to try all of them in one trial. But if the situation is that we cannot, we will proceed with those that we have at the end of the day. The case is not necessarily dependent on the 2 being added. We have explained before you, Exhibit G is clear as to what evidence do we have. It would have been better for all concerns, not for witnesses to have to testify twice and all of that, to have those 2 added. But if at the end of the day the court finds that it will be a delay, then we'll proceed. I don't know whether that answers the court's question.
Yes, no,
thank you.
We have touched upon Exhibit G, and I've got a few questions to raise with you with regard to Exhibit G. Some of them, or some of the questions that I had, you have already touched on. You referred to, you said, an eyewitness state, I saw X firing a shot at the deceased.
Yes.
Are you saying the type of evidence that you have here, we have the evidence of eyewitnesses?
There are eyewitnesses who saw the shooting.
And the eyewitnesses, are they going to implicate the accused before court?
One will implicate the accused who's not here before court. If your worship understands Exhibit G, we have identified one of the shooters as one of the people who
Yes.
are in Swaziland.
Yes.
The second shooter at this stage is not necessarily identified by a witness, but the scientific evidence shows by process of elimination. Let me put it this way. There are 3 people that we're placing in the Mercedes-Benz.
Yes.
2 come out. This is now by process of elimination of the scientific evidence. 2 come out.
Are they identifiable?
Now, there's a witness who identifies the one shooter. The other one is not necessarily identified by the witness at the time of the shooting, but he's placed in the Mercedes-Benz before and after. And by now having, out of all the role players, we are saying, for example, that these 4 and these other 2 that are not here. The process of scientific evidence says these 4 were here at this time of the shooting. The only 3 could be here is these 3. Out of these 3, we identify 1. And when you look at the description of the second one, because we have managed to place, for example, accused number 1 is placed in a Mercedes-Benz, together with applicant number 4, as well as the shooter in Swaziland. Now, those are the 3 that were in the Mercedes-Benz at the time. Now, 2 comes out, and definitely this person who fired the second shot is not accused number 4. By a process of elimination, you argue. The only inference you can draw is the following. Even if I have covered my face, but I came out of that Mercedes-Benz and ran back to it immediately after that, and everything else places me there, except one who say that's definitely you. But the inference can be drawn from the scientific evidence as to who the second shooter is. I'm not sure that it answers the first question.
No, I follow. One other aspect that is of concern to me is the allegations which are made by the state. The applicants were contracted to kill. They were hitmen. Is there evidence to that fact, that the applicants were contracted to kill?
Without giving much in view of the sensitive nature.
Yes, I accept it is sensitive, but there is this wide allegation which has been made. These are contracted killers. These are hitmen.
Your Worship, if one looks at the evidence of how the murder was committed, how everything else happened, collection of guns, use of stolen vehicles, use of unlawful firearms, shooting thereafter, payments. Inference we are drawing is, these are the hitmen. They were paid equal amounts of money for this job that all of them have done in view of the roles that they have played in the commission of the offense. Bearing in mind that hitmen do not necessarily have to know the reason why they are committing the offense, they are killing. They don't even have to know the motive. What is important to them is we do the job, we get paid. Now, the planning, the evidence showing the planning that from the time that the deceased number 1 arrived, he was followed. From the time he arrived at the airport, he was followed. Where was he taken to? What happened? Roles played. One goes inside the wish and make sure that I can see him and communicate with the other. The planning shows that this was a plan to kill. Now, after they have killed, what then happened? They are paid. The inference is, these are hitmen. I will argue the issue of the payment later on, as to why we say it's a payment. But the fact of the matter is, that is the evidence. Therefore, you don't necessarily at this stage to say, on the prima facie evidence, do I necessarily have to know or have the person who ordered the hit arrested to make a decision whether to grant bail or not? On the evidence before this court, is there enough evidence prima facie showing that this was a contract killing? I will say yes.
Does this include applicant number 3, who is said to have not even been at the scene of murder at the time? He was languishing in hospital.
Exactly. Now, we are saying, as part of the plan, as part of the execution of the plan, we need a stolen car so that it could not be detected. We need the firearms to be used for this purpose. And we have shown to the court that this was not the once-off incident of accused number 3 providing this. There's Area 53, which happened immediately after this. We have shown to the court that this is the role that accused number 3 is playing, where he says, arrangements made, come and fetch the tools to be used. He gives. And then after the tools have been used and after everything has been, it's brought back to keep it for us. That is in February. In March, Area 53, same thing happens. You give them the Mercedes-Benz, you give them the cars. Unfortunately, the Mercedes-Benz got damaged, they dumped it. But the bottom line is, his role is, I will keep the tools and whenever you use them, you need to use them. So that the police cannot easily detect what is going on. The rest of the team comes from the north, he comes from the south.
But again, applicant number 3, he is not part of the people that are paid. He doesn't receive 133,000. How do we associate him with this group of the so-called hitmen?
There is no
Other than the firearms that he allegedly supplied and what have you. How do we associate applicant number 3 with the firearm, with this? Because he is not on the payroll.
There is no bank record suggesting the payment insofar as accused number 3 is concerned. At this stage, it doesn't mean there was no payment made. Those are part of the investigations that we have information, but we did not put it on the record as yet until it's verified. We don't want to put allows information in court just for the sake of doing bail application. Those are one of the things that we're following up because it is clear from the nature in which they operated that this is the role that he has been playing all along. Therefore, one can say can never be fulfilled. In trying to make the court understand this, at this stage, that is his link. We are still investigating. It could have been a cash payment. We are following that. But we're presenting what we have at the moment. May I approach my...
Yes.
Thank you, Worship. I'm reminded of something as well, Worship, that I might argue on this aspect. Let me start with the first question of contract killing. Not necessarily, I'll come with accused number 3. We have led evidence that accused number 5 opened that bank account on the very same day the matter was, the money was transferred. Soon thereafter, the account was closed again. Just to show. The information that we are following up. After the shooting, there has been an exposure on applicant number 3, developing houses and everything of that nature immediately after the shooting. He is not employed. He alleges he's washing cars, but the amount of the houses he developed rings a bell. That is something that I said earlier on to Worship that we were following up, that there might not have been transaction, but a cash payment. However, the bottom line at this stage is, did he play a role? And what role? And it can never be that he offered these tools for free. More especially in this kind of, if I can put it loosely, a job that has been given. It was not any simple individual. If I don't want to say I'm equating him to other people, more than that. But the stature of disease number one would say, but even the amounts that we alleged were paid. One in court will hear about 5,000 rands for the hit, 10,000, but this one, it explains because of the nature of the person that was supposed to be killed. I'm not sure that I've answered your worship on the consent. May I then proceed unless there's anything else? Because I was going to come.
My questions are based at establishing whether there is a case, because that is the question that this court has to answer at the end of the day. That is where I'm directing my question. Is there a case against the applicants before court? And if there is a case, is there any risk if they are granted bail? Because those are the paramount questions that I have to answer at the end of the day. So that is where I'm directing my questions.
As a court process. As I have indicated to your worship before, there's a manner where I've structured the submissions I wanted to make. Part of what I'm submitting falls to the risk, that is now our section 60 subsection 4 to A to E, and part of what I'm going to submit falls to the issue of the case. But I wanted to respond first and then come to the issue of the case against the accused, as that is now the first step. Whether is there a case, are there exceptional circumstances? Once we have, or the court have analyzed and find that they are not or they are, then the second leg, which is now the inquiry about section 60 4A to E. Now, as I am going along responding to what my learned friends submitted yesterday, some of the court's questions are answered. Thank you.
You may proceed.
The doctor's note. That might go to the risk. I think we have highlighted that even on our affidavit. Under those issues of section 60 subsection 4A. One of the emphasis that I've indicated at the initial stages of my submissions is accuses evidence. The applicant himself, having been given an opportunity to do so, adduced evidence that here is a note from my doctor, Governor Moodley from Tubatu, showing that I'm asthmatic.
The document dated 11 March.
Yes, sir. He adduced that evidence. It later transpired, as per Dr. Moodley's statement, that it could not have been applicant number one who was in his room. It was somebody else. And to make even things worse, because that person did not have an identification document with him, I did not write the ID numbers in the form. That is what Moodley is saying. And if one just take a glance of that document, you can see the handwriting are even totally different. But the one presented in court has got an identity document, identity number. Now, we have highlighted the issue of one of the case law where if a bail applicant, knowing it to be false, submit that kind of evidence in court. That single action of applicant number 1, 4 consequences. 1, the misrepresentation to the court. 2, the forgery itself of putting the ID number that was not put. 3, the pleasure of saying, if you look at that document, I was the one who was there. And I'm attaching it in my documents as part of saying, this is the proof of that. 4, submitting it to court as utter. 1 action. And it does not stop there, Your Worship. He goes on and makes a bold allegation that the state must assist him to have warrant officer Clay arrested for giving false information in court about him not having a firearm license. When he realizes that he has made a mistake, he makes an application to withdraw. What is important? He realized he was wrong about play and withdraw the statement. He did not withdraw the doctor's note. He had an opportunity to do that. All he's saying is, go to Westville, you will find that I'm being treated there. And he puts the blame on the state, whereas he has the responsibility to adduce evidence. All that he needed to do is to ask for this court for an order that those documents be released. If he so wanted, not blame it on the state. Because the duty to adduce such evidence lies with him. Now, applicant number 5.
Sorry, before we leave applicant number 1, what are you saying? What are you trying to say by annexure KP5?
KP5.
What are you trying to say?
If I can just go there. Your Worship, can we look at photo 13?
Before we go to photo 13, let's start at photo 1, page 2 of the album. What is written underneath there? There is an inscription, or there are some words that are written there, and there has been concerns raised. We don't understand what is that.
Situlwane thina mkhwanazi igazi lomuntu ofile asilesabi. Singawavimba amatuba amenze suka phezulu kwesiduli uzokugugisa umuthi.
What is that? Ms. Dlamini.
We can give it to her to interpret for us.
What is being said here, Ms. Dlamini?
We at Tulwa, the Mkhwanyazis, are not scared of the blood of the deceased persons.
Is that now the assistance by Ms.
By Ms. Dlamini. We can make him to come to
Should she not put it herself on record?
Oh, maybe she can read it to us.
Yes, I think she should tell us what is
As a
being
court
said.
basis.
Your Worship, the interpretation that I got from it is that it says, at Tulwa, the Mkhwanyazis are not scared of the blood of a deceased person. We can make him come to a standstill, move away from the building.
What are you trying to say instead, Mr. Kaba? I understand one and foremost that this may border or this may be character evidence which the trial court is not going to accept because it speaks of character or may not admit. But what are you trying to tell this court?
For bail purposes.
Yes, for bail purposes.
It is admissible.
Yes.
That is what we're trying to say. Who is the
That
person?
is why I'm asking you the question. What are you trying to say?
We are trying to tell your worship to say the bail applicant before you is a person of this nature that swears, that carries guns in public areas so as to portray that it should be feared. And this is a person who operates in a taxi industry where he goes on to say, we can put Tuba at a standstill. Look, I think this, the emoji that says, I swear. I swear. This is the kind of person that if you release him on bail, he has already told you, I want everybody out there to see what kind of a person I am. I must install as much fear as I can to everyone who's there. More especially when one views it in the nature of the business that is in. And we know, we cannot run away from that fact, that the taxi violence in KwaZulu-Natal in particular, this is what is happening. And if one understands the message he wants to portray out there, fear me. This is who I am. I can do anything to put Tuba to stand still. And not only, your worship, is he taking a video, he circulates it. It's not a video that he's taking for personal use that people in my homestead must see. No, put it out there so everybody can see. And read the words that I want to portray to those people. Not only am I doing this in my yard, Photo 14, public area, around the Richards Bay area. There, putting a gun, having a smoke, whoever is passing, this is me. I'm not going to touch it. Portraying, now, if one looks at this evidence and say, okay, here's a person who wants everyone out there to fear him. It lends to a number of people. And we have, for example, made a submission in the affidavit to say, if one looks at photo 13, imagine his enemies that he has indicated in his affidavit come in that kind of situation and a shootout ensues. Who is in danger? If he moves around with automatic rifles and go and display them in public areas, Anything can happen. This is the nature or the kind of a person the applicant number 1 is. That is what we're trying to portray. If your worship understands. Because we're dealing with the character of the bail applicant. That is someone who really needs carry guns, whatever he wants to do. And not only do that, but send messages to people that must be free.
Okay, let's move on while we are still on applicant number 1. You claim through warrant officer Pillay that he did not comply with the conditions. Inter alia, you are saying he did not remain at his parental homestead in Tubatuba, but he moved to Nseleni. Concerns have been raised that you did not do what you did initially, that is making inquiries at the people as to his whereabouts when you did not see him, and that you did not explain his constitutional rights, whatever information you obtained from him as to his staying at Nseleni was obtained unconstitutionally or without you having complied with his constitutional rights. What are you saying?
May we start with this position? Police went to his home in Tubatuba, which home he said he's going to reside in. A person was found. An inquiry was made from that person as to the whereabouts of the applicant. The person gave an information that ever since he was granted bail, he never came back to stay here. He does not know where he stays. That information is relevant for the bail application. The identity of the person is kept for the safety of that person. We did not want to disclose the person who gave the information. It is not, if it was a parent or a relative. Now it's someone who stays in the property but is not a family member.
You are allowed to give hearsay evidence, but you do not state that that is the information you have. We made inquiries and we do not want to disclose the identity of our informer, but we have hearsay evidence to say that ever since he was released from bail, he never went back to his parental home.
We said that in our affidavit. We said we found the person. We said that in our exhibit G.
Please take me there.
Paragraph 169, Your Worship.
169. Upon inquiry from a person in the yard, my team was informed that since applicant 1 was granted bail, he has not been. Thank you very much.
Thank you, Worship.
Of course.
Now, because the
Was that now why you then went to waylay him at the police station, knowing that he was going to go?
as part of the reporting conditions. Upon arriving there now, is asked, but we have been at your place. We didn't find you there. Where are you staying? Let me go and show you where I'm staying at Nseleni. We took them. It's not any kind of evidence that makes one to be informed of his rights. We were looking for you, we couldn't find you there. Where are you staying? He said, no, I'm going to go and show you. It's not disputed actually. It is not disputed that issue. That portion in the replying affidavit of applicant number 1 is not disputed. if my memory serves me
But
well.
again, there is a concern raised that he has shown you now the place at Nseleni. Where is a confirmatory affidavit by or statement by whoever at Nseleni to say, yes, I'm renting a room out to Mr. Mkwanazi. Mr. Mkwanazi has been staying with me here, paying X amount of money per week, per month. Where is such information?
May I take the court to paragraph 171. But one has to read it with 170. He arrived and was arrested. He was asked why he was not staying at his home as per the condition he gave to the court when granted bail. He indicated to my team that he received information that his life was in danger from the taxi rivals and therefore moved away from his house. Upon inquiring, he showed my team an address in Nteleni where he said he was hiding from his foes. He showed us a room at the back of the premises. My team found a bag with his clothing still checked and indicative of the fact that he can move anytime from that place. There were no items of clothing indicative of the fact that his wife was staying with him at the said address. He was asked why he did not inform the officer of the changes. He could not give an answer thereto, save to say that he moved away for fear of his life. Now, it's not from the explanation given by applicant number one. It could not be a place where one could say he's permanently staying. For one to say, to ask a friend, but as you are saying in the affidavit, it's clear that he was saying, I'm just hiding here as of now because of these reasons. Even the fact that we found the bag even packed, it was not to be more necessary to ask one, but why is he here? Is renting, is doing that? Because we are saying, this is the explanation that he gave us. So we accepted what he gave us. So to the state, it was enough for the state to understand that this is the reason that he has given.
Thank you.
Thank you. Now, I was dealing with applicant number 5 submissions, unless the court wants to take me on something else before.
I think I've answered on the question relating to applicant number 1. You want to move to applicant number 5?
5 years, on the submissions made yesterday.
May I proceed?
Your Worship, there is this issue of accused 5 handing himself over.
Yes.
And the Worship is asked to consider that and find that he is not a flight risk. Now, there are certain factors that your Worship should look at before even coming to the point of handing himself over. Number 1, the applicant himself in his duty to adduce evidence vehemently made an application that you should admit the DPP's affidavit to Swaziland. And in his application there too, part of what was said was, you will be denying him, Your Worship, his right to challenge evidence if you do not accept this. That is part of his duty to adduce evidence. Now, the difficulty that he's facing now is the fact that in that evidence that he asked you to accept, there's a request for him to be arrested in Swaziland. Now, they are saying to you, here is the evidence that I was in Swaziland. There was a request for me to be arrested in Swaziland. That's what they are saying. Because they are saying, accept this evidence. If you accept it, your worship will see that it is detailed as to why the state says he was in Swaziland. Why they are requesting for his arrest in Swaziland. Now, that is the first point. And the state is saying, yes, he was there. We even have proof that at some stage he purchased at a shop, I think it was a ShopRite or something, using his bank card in Swaziland. Now the applicant himself corroborates that by asking you to allow the evidence of his request to be arrested in Swaziland. You cannot ignore that. It's his evidence. If you accept the contents of the DPP's affidavit, it says he was in Swaziland.
But the proof that you say you have of him making a purchase at ShopRite, is it part of
Exhibit G? It's mentioned somewhere, Your Worship, in Exhibit G. I think that choosing himself even said it was a visual card that was used, but he left the phone with the two. His phone is with the two in Swaziland. It's somewhere in his. It's common cause between the parties that there was a purchase by his bank account. Common cause between the parties. But he's saying it's a visual card that was used, and his phone was left with the two that were in Swaziland. So it is common cause that there was a purchase. But I'll get to that paragraph, Your Worship. It's spa. It's a spa, not ShopRite. It's a spa. It's a spa. Your Worship. We mentioning this on paragraph 2, word 4. My apologies, Your Worship, it's in 213. We engage the offices of Interpol and crime intelligence units to assist us in tracing applicant 5 and the two demanded brothers. It was established that applicant 5 was indeed in Swaziland with the two brothers. There was evidence that he was indeed in Swaziland because his bank card was used to purchase in a store in Swaziland. Crime intelligence officers also confirmed his presence in that country.
Thank you.
Now the issue about this aspect, Your Worship, is the fact that we have now also handed in his passport. It's not stamped. It's clean. No stamp at all of him leaving South Africa.
So you are saying there is evidence that he was in Swaziland. Under normal circumstances, one would have used his or her passport to go over the border. But you are saying in his case, although he is in possession or he has a passport, there is no indication on his passport that he ever went there, yet there is proof that he was there.
That's correct. And his passport was valid even before him being found in Swaziland. Meaning the passport never came to be issued to him after that. It was already in his possession when he went to Swaziland. If Your Worship, it's not a question that he went to Swaziland and then came back and then applied for a passport. He went to Swaziland whilst he was already in possession of a valid passport. Now, one might take this lightly, but if one thinks about it more and more, it does make a little bit of sense. The two Ndimande brothers are arrested on a Saturday morning in Swaziland. He's not yet arrested. On Monday, following the Saturday, it's all over the news that the two Ndimande brothers are arrested. The other two are not yet arrested. On a Tuesday, the police go to his place of residence. Already the issue of the Ndimande brothers being arrested in Swaziland for this case is a well-known fact in South Africa. So nobody knows. He is not found at his place. Now, bearing in mind the worship that he has been in Swaziland before, there's evidence for it. And he was with the two brothers at the time. There's evidence that we have read for it. Now, in his mind, he's saying, the two brothers have been arrested where I was in Swaziland. Now, the police have come to my home in Pietermaritzburg area, Kembadown area. They found my mother. My mother tells me that the police have been here. The same police that have arrested the people I was hiding with in Swaziland. What choice do I have in the present circumstances?
But he was threatened.
I'm coming to that, Josh. I'm coming to that. What choice do I have? I cannot run away now. It's clear that this policeman can find me anyway if they manage to even get my two brothers in Swaziland. Now, the state is saying there was never a threat to your mother. They're actually saying there was a threat. I was told if I don't hand over myself, my mother was showed the place where they will bury my body next to the crowd or something. The police are disputing it. Now, if you accept that this has happened, if the court accepts for one that this is what happened, is that not an inducement, not a voluntary handing over to the police, but to say, hey, if I don't, I'll be killed? If you accept it for once, to say this is what occupies his mind. Therefore, the pressure that was on me made me to hand over myself, not necessarily that I wanted to. If we accept this evidence, it might seem far-fetched, but he chose to tell you that this is what was told. Is the handing over voluntarily or induced by the circumstances? Therefore, can you accept to say, yeah, you know the flight risk? Because when the circumstances change, you act otherwise. That is the evidence. Which takes me to accused number 2 on this very same issue. In his affidavit, I have indicated to you, Your Worship, earlier that Section 60, subsection 11C says, and such evidence becomes admissible in any subsequent proceedings. The affidavit he made in the Perea 53 application, he was given a warning. Now, this application is a subsequent proceedings to that. There was no objection when applicant number 1, for example, chose to use his affidavit in a bail application that he did and use the IO's affidavit in that application, because that is the principle. Now, in that affidavit and in this one, before this court, it is clear as to why he moved from Durban and relocated back to his hometown in Mpangeni. And stayed at Mpangeni, and again for the reasons that made him to leave Durban, he went to stay in Gauteng. It is in his evidence. When it's becoming hot in the kitchen, I relocate. That's the bottom line. Now, is such a behavior not indicative of the fact that when the pressure mounts, it will change another? The same applies as applicant number one. And this is what they told you, should not us, to say, we live in this fear because of the taxi business that we're in. The same applies with the passport. Exhibit KP 6. Thank you, Mr. Wilber. KP 6 was read to him in court, interpreted, fortunately, by Ms. Zamini, who is also here. Where he says, Your Worship, if you, as Your Worship, arrive at KP 6, page 6, yeah, KP 6, paragraph 21.d. I do not have a valid passport which may enable me to leave the country. I undertake to not obtain and or apply for a passport for traveling without the permission of the investigating officer or the public prosecutor pending finalization of the trial. If some emergency arises which may necessitate my traveling over the borders of this country, I will only do so if permitted by this honorable court or investigating officer. The difficulty with that, Your Worship, is the following. As Your Worship has done in this court, have you heard the contents? Yes. Do you confirm the contents? Yes. If the state did not highlight this, that court would, in fact, that court still has this impression. Because the bill is not finalized. That court still has this impression that there's no passport. There's no explanation given. At least this bill has now come to an advanced stage. But the bottom line, Your Worship, is before that evidence was admitted, the contents were confirmed by the applicant. The contents were confirmed. There's a reason for that. There's a reason for the court to say, it has been interpreted to you. Do you confirm the contents? And the applicant says yes. I will make an example. Paragraph 14, the previous page of KP6. I support my 5 children. My net monthly income is an amount of approximately 400,000. It was inserted by hand. This information could only have come from the applicant himself. For whoever is drafting to put that amount was inserted. And KPM 6 was commissioned on the 2nd of February 2024. Now, a month later, Exhibit D, paragraph 35. I generate an income of 250,000 rands per month from my taxi business. The very next month. Previous month it was 400,000 in February. In March, when we started the bail application, the amount suddenly changed. And he confirmed it here in court. Are we going to blame the drafter again? I generate an income of approximately this much a month. Not to say, sometimes I do this. Basically, what I'm telling you is, whatever good or bad, this is the amount I generate monthly. That is what is being said. Fluctuation would be sometimes, depending on the business. But generally, what I'm saying to you, it means on average, this is what I'm making a month. But the fact I'm trying to make, Your Worship, is if there was a mistake, about the content, because the 400,000 was mentioned, right, 400,000, and they wrote it on here. The 250 is mentioned at the start. It shows, somebody said it's no longer 400,000, it's 250,000. So we cannot blame the drafter, because the drafter got the information from the deponent. That's the point I was trying to make. If you accept that there's fluctuation, of course. Applicant 3, I did not mention a lot, Your Worship, about I wanted to make submission about the propensity. I think your Worship has taken that issue with my learned friend.
Why do you say that accused or applicant number 3 is guilty of murder?
For this matter.
He was in hospital. He was injured. There is proof that he was admitted in hospital. He was shot in his hand.
We are saying to your Lordship, Your Worship, my apologies. His role was not to be present at the shooting. His role was to supply the machinery for the job, and for the machinery to be brought back to him after the job is done. That is his link. And proof of that is that indeed, after the shooting, the gun is found on him. The murder weapon is found on him. It was brought back. We have evidence that shows that it was brought back. He made arrangements. The guns were handed in. When the shooting is happening, he happens to shoot himself. It was not his role to be present at the scene. It was not his role. His role ends in saying, this is the job that's supposed to be done, give us the information, give us the tools. The tools that are used, he happens to shoot himself when he's busy doing whatever he's doing in Umlazi and goes to hospital. Even if he did not shoot himself, we are saying it was not his role to be present at the scene. His role ends and starts with the supply of the machinery. Therefore, it was never our case that placing him, or we wanted to place him at the crime scene. That is not his role. It is clear that this is the role that he played insofar as the murder is concerned. Therefore, if one has to look at the doctrine of common purpose. If we can prove prior agreement, if you can prove prior agreement, okay, this is coming to the picture. But by common purpose, he committed the offense. Offenses. Therefore, Your Worship, his absence at the scene does not necessarily mean he's not part of the plan to kill the deceased. If this is what you're saying. That it's clear from the evidence that, as we allege, there was an arrangement made that, please give us that. Don't come, but give us what we want. We'll bring it back to you. This is the job we're supposed to do. Do the job, then it's given back to him. So it was never his role to be present at the scene. Whether he shot himself or not, it was never his role. I hope that answers the court's question. We may take a short break. I see it's 25 past 10 already. I think I've been talking for a long time. Maybe a 10 minutes break will assist. Or we take an ADT.
Can we take 15 minutes?
Yes, sir.
To be back at quarter two. We agreed on that. Are we agreed? 15 minutes break. For a chance and for a two.
refer the court to one case that I managed to find on the issue of applicant number 3. Matter coming from this division, but it was also held in the Supreme Court of Appeal. Ravinji Soni, R-A-J-I-V-W-E. Soni is in S-O-N-I versus the state. Case number 465 of 2019, in brackets 2021, ZASCA 57. On paragraph 35 of that judgment, it reads as follows. In our view, the agreement which Dlamini had knowledge does not exclude a wider agreement of which he was ignorant. In Tebello, the Constitutional Court explained that the doctrine of common purpose permits for the attribution of the criminal liability to those persons who jointly undertake the commission of the crime. The conduct of every person who acts pursuant to the common purpose is attributed to all who form part of the common purpose. A common purpose may come about by way of a prior agreement, expressed or implied, or by way of active association and participation in a common criminal design. In a consequence crime such as murder, the ordinary requirements between the conduct of the accused and the death of the deceased is dispensed with, provided that the accused actively associated with the conduct of the perpetrators. Now, logic dictates, Your Worship, submit. This minus applicant number 3 in the whole scenario. Just take him out, his role, everything. What are we left with? No firearm, no stolen vehicles, nothing. But in the pieces of the puzzle of this agreement, he is needed to supply the following. And it needs to be stressed, Your Worship, perhaps I might have forgotten it earlier on. To indicate what he said earlier on, that there's a pattern wherein he seems to be the supplier of fire and vehicles. Your Worship would recall that there's a matter that is charged under Mayville Cast 226 of 5 of 2022. This is where we said the cartridge cases that were left in that taxi violence shooting where people died meshed with the second firearm in this matter. So the 2 firearms that were used in this matter were collected from applicant number 3. One of which was already used in the matter is linked in 2022 already. So if the court follows what my submission is, that he keeps them as and when they are needed, they come and fetch it. The Mercedes-Benz was robbed in January of 2023, used in this shooting, came from him. Used in the 53, which is in March 2023, a month after this one, where is also linked. Now, one can see the thread to say, as and when the North guys from Mpangeni and others want to do a hit, the supplies. This is the information. Active association as the common purpose. But that's the prima facie evidence that you are placing before. Submissions were made to finalize this aspect about number 2, propensity to commit an offense, about states saying they're going to join the matters and all of that. Our submission is that it doesn't take away the fact that there are these pending matters where violent crime is involved. They are, even if they are joined. But for purposes of the bail application, they exist to show that there is this propensity. So the joinder thereof makes no difference, that they are tried together. That is for purpose of trial, not the bail application. Quickly moving to accused number 4 in submissions made yesterday. Starting by the duty to adduce evidence, Your Worship. Your Worship raised a concern with my learned friend that there's a bank statement attached to his affidavit, founding affidavit, admitted as Exhibit F. The period of that bank statement ranges from April of 2022 up to May, if I'm not mistaken, of 2023. Of importance, Your Worship, is the fact that yes, Your Worship, it's May of 2023. The period of December 2022 to March 2023 is not there in his founding affidavit. At that stage, when he submitted Exhibit F, it was not common cause, as Mr. Jorgensen has submitted. It was not common cause that there was money transferred, because the state had not led its evidence. It was still the applicant filing his application. And it was at that stage that it was highlighted to his counsel to say, in an attempt to assist you on your duty to adduce evidence, there's a certain piece of evidence that is missing. Take this opportunity, if you so wish, as a bail applicant to adduce the evidence that is missing. Which aspect the applicant decided not to take. Bearing in mind, Your Worship, that at that stage, he had the duty to adduce evidence. Therefore, the state then came and submitted KP1, and the applicant was again afforded an opportunity to reply. You cannot shift the onus that is on you to adduce evidence to the other party. Now it became clear to you that there is this payment alleged, which you have the evidence, but you chose not to actually extract out this piece of evidence out of what you wanted the court to see. Still, you have a duty to adjust that evidence. You choose not to. Once again, this aspect was raised by the state. Do not forget that you have the duty to adduce evidence. Where is this clear? Again, the applicant chose not to. Shifting it to somebody else is not going to help. Now, one has to ask himself one question. Why? You have taken a conscious decision to make the court aware of the existence of bank statements ranging from a certain period. But you decide not to divulge the crucial period. Whereas it is your duty to adduce that evidence. Much has been said about the arrest or not of the person who deposited the money. Let me perhaps ask in this fashion. In a chain of participants, we show that each participant has played a specific role in the commission of the offense or in the execution of the plan. And that evidence shows the criminal liability of that participant. Once more, we said, if those that are in Swaziland are not extradited back to South Africa at the time when the matter to be set on the road for trial, it doesn't mean we cannot proceed with it. Because there is evidence against those that are arrested. It will supplement rather than weaken the state's case if others are arrested. Now, but if you allege that X paid the money for this specific purpose, why not arresting X? Don't wait. Deal with what you have now before you. Don't shoot blanks on the spectators for now. Deal with what you have in front of you.
Yeah, but submissions are made. Submissions are made that you claim this was a hit and the money paid was for the hit. This is defeated by the fact that you have now found out the source of the payment or of the money and you're not doing anything about it.
That is not what you said. That's the issue. That is not what we said. We said we are following this and investigating this matter. On this aspect, what we have established is the following. As it is even indicated by the applicants themselves in this court also. In their founding affidavits, they are saying, this is the kind of work that we are doing. None of them said we work for applicant number 4 in their founding affidavit. It's number 4 who says, I hire some of my co-accused for something. Doesn't even mention the names. Now, the state comes with this evidence to say, even though applicant number 1 says, rather applicant number 4 says, I've been paid for services rendered, we are saying there is no such evidence. You said, we investigated and there is no such evidence that I was disposed. You have a duty to adduce evidence. All you are saying is a blank statement to say service is rendered. No invoice attached, no contract attached, nothing. Nothing. There's a bold statement from outside that says, no, we are a legitimate company, we paid him for business purposes. Nothing else. The state is saying we've got nothing. There is nothing showing that we're entitled to that, to those funds. Nothing. Is there any evidence before this court? Brought by applicant number 4 to show that that money was paid for this specific service. Nothing. The co-applicants get money from him of an equal amount. Money which we say the previous day we're linking you to the commission of this offense. And you happen to be in his area where he stays when these monies are paid. Equally so. And everybody who has been paid is a participant in this offense. Where are the services rendered by applicant number 1, applicant number 2, applicant number 5, to choose number 4? If you look at KP1, for example, Your Worship, one time I have it, the other time missing. One is given dividend. One is other given wedding things, taxi loan, car repairs, dividends, buying house. If it's a legitimate business, there Mr. Bradley says on the last money he pays to the school fees. And indeed, it was paid to St. Benedict's, where his child is attending school fees. Now, where is the evidence to show that they have got shares in Guab's mining to be entitled to a dividend? At one time, we're told, they're waiting for me. At one time, we see taxi loan. I don't know what is that. Now, and the manner in which this money is distributed, and bearing in mind, Your Worship, that it is paid to people who are linked to this offense the previous day. Now, picture the following, Your Worship. I am charged to coordinate the hit. That is my role. What I will do, I will source the people that are supposed to carry the offense. And then I'm the one coordinating, and I'm supposed to pay them for the job done. And in the process, I'm saying, do you need cars? I say, yes. Here's the polo, use it. It's rented in mining. Here's the Grand I-10, use it. It's rented in mining. But the car where the shooters must come from must not be linked to us. Get another car. Number 3 brings the Mercedes Benz. I need not have any interest in the reasons why the person must be killed. If I'm paid, it's okay. I'm the coordinator. Now, if the evidence shows that this is what you did, is the absence of the person who asked me to coordinate weakens my case? I beg to differ. Prima facie before you is the fact that this is what he did. And we are saying to you, not only did he coordinate, he was present. One would say, State is talking about cellular phone triangulation and all of that. You decide to take and use the modern technology that allows you to have a bank card in your phone, which we normally call it a visual card. That visual card is linked to your cellular phone number. My kids, my uncle, my father might have visual cards to the bank account that I'm holding. But those visual cards are linked to their cell phone numbers. Now, here is someone who's tapping at the parking lot and pays with a visual card that is linked to his cell phone. And he's not disputing that I was at the airport. He's not. Right at the beginning, when the deceased leaves the airport to go to the hotel, close to midnight after the shooting, the guns are being brought back to where they are supposed to be kept. Here's the polo at the garage. It's not his polo, it's a hired. The tracker of the polo says that. Boom, taps again with the same visual. In the middle of all of that, there is this phone he uses to tap with at this starting point and ending point in the vicinity of. It's supported. In the vicinity of Umlazi, it's supported to pay at Umlazi garage. And en route there, you pass certain areas, like they forgot the Dale Bridge. You pass there, going to the garage. Your cell phone is going. It says you moved from Wish, and then you went there, and then you tapped.
But is there footage of him coming from the airport en route to Hilton Hotel?
Your Worship, we have argued that in our heads to say, Your Worship would recall that the investigation took stages. As and when it came to a point of identifying a vehicle, we have identified vehicles, a number of vehicles, to say, but which one could it be? By process of elimination, came to a BMW. By the time we went to the airport, they keep the footages for a specific period. Like if for example, there's a robbery at the garage next to the court, they'll keep that footage for, say, 2 months, and then it's overridden. So if you come late and ask for it, you might not find it because of the system that they are using. Some of them have a backup, some of them don't have. The question the court can ask itself is, if we had it, we would have presented it. If we had it, we would have talked about it. Because we are saying we were at the court and this is what we're looking for. So if we can't find it, if we don't have it, we cannot say we have it. But at least there's a record, the bank record that says that visual card linked to his number was used. Just a second. So, the closest we can get to the airport, fortunately, is the toll. The toll that one uses when it gets out of the airport to join the N2 camera. There we have a view footage of the BMW. There we have it, driven by a choose number 4.
Does it show applicant number 4?
It shows one individual in the vehicle. One individual in the vehicle. Unfortunately, the angle from where it is, you cannot see the driver. But you can see the vehicle itself. And now, taking that into consideration, I'm happy that the Lordship has raised this. We now have a statement. Let's start by saying, at the time the deceased is leaving the airport, applicant number 1 pays 4 minutes or 3 minutes after that, parking lot getting out.
Applicant 4.
Applicant 4, the visual. The deceased vehicle passes that toll. There are 2 cars behind him, and the 3rd car behind him is the same BMW of applicant number 4. It goes to Hilton Hotel in Motsoane. The same BMW is there. They put the number plate and everything. And the cell phone records showing that direction of applicant number 4. Now, Mr. Pile traces this BMW and finds it with an old white car. Knows where it is, get a statement from there. We bought it from Caleb, they get a statement from Caleb. He files it. For some reason, he does not know, even the team does not know. Number 4 pitches up in their office. They have never contacted him. They have never asked him for any explanation. He pitches up. With an attorney, Mr. Tebello, who is now deceased, may his soul rest in peace. We hear about the BMW, we want to give a statement. And they give a statement, which is KP 8. No, not KP 8, what it is?
It is moving. KP 8 is moving.
KP 4.
Yes.
He explains how he got hold of the BMW, how he exchanged it for a car from wherever, and then he says on paragraph 11, I then started using the vehicle for my personal use. And then only in May that he took it back to Kenya. Your Worship asked Council yesterday about what he says about the BMW, whether they were driving on the day or not. Was his personal? This is the only car he had at the time, if you're looking at the statement. Because he has exchanged the Volvo that has now been broken and all of that and took possession of this vehicle. If one understands this statement. Now the BMW happens to pass the toll, and you cannot pass that toll from the N2 coming from Mbangi. You only pass that toll if you come coming out of the airport. That's how it's situated. And the timing of the payment and the parking and the passing of the e-toll explains that it was driving following the deceased vehicle. I have indicated, Your Worship, that Part of the evidence we have had in the founding affidavits is that none of the applicants ever said they worked for applicant number 4. It's only after there was this disclosure to say, but let's try to get closer to his version. I once worked for him at some stage and I did that. They had to explain this money. One says, no, he gave me to buy house. But why equal amount of money? Why equal amount of money? The day after.
Coincidence?
Not in this nature. Not in this nature. Because, let me argue in this fashion.
Well, that's what is stated in the papers. I think it refers to Lindani, applicant number 2. Payment to Lindani was a coincidence. Somewhere in applicant number 4's papers, it's so stated. But, I'm not sure whether it's reply or it's a founding affidavit. But yes, I remember seeing that.
It appears that coincidentally he's been owing all of them for different roles that he played in his life, as being his employees for whatever different roles that they worked for him. And now, if I work as a driver, and the other one works as a security, and the other one works as a mechanic, equal amounts of money. I'm owing you all equal amounts of money. Doesn't make sense. And strange enough, we are given an impression from the affidavit that this man is making money from mining. So I was saying all the applicants, inclusive of those that in Swaziland, were patient enough to wait for their money at the same time, when you get it at the same time. Because we are told he's been owing them for months. All of them have been patient, consistently in the same manner, to get it only on the 11th. Doesn't make sense at all. Vis-a-vis what the state is alleging. Hence, the issue of the statements of Caleb was out still in the BMW, Your Worship. If Your Worship follows Exhibit G as to what happened, the statements of the white couple who bought the vehicle and Caleb were obtained. After they were obtained, filed in the docket. Caleb came to ask for the copies. The IO did not think otherwise of that. Gave him the copies. Investigate the matter. Now, the Grand I-10 is one of the cars that is now seized, because that is the car that was left and the Mercedes-Benz was taken, and taken back and the Mercedes-Benz was dropped off. That is the evidence. On the KB hole, find these two statements. That of Nosworth and Kelly. I made copies of the statements to Kelly. Let me ask him, but why they end up being in the Grand I-10, which now the Grand I-10 is a subject of my investigation. I've even seized it. Not only does it do that, it takes photos. They investigate. They take photos, it's called the SRC, they take photos so that this evidence becomes relevant at the end of the day. It's only then that Caleb tells him, no, I was instructed, actually forced by applicant number 4, that he wants to see those statements. Now, after he has seen those statements, he decides to take his attorney to come and see the investigate officer.
But what was the importance of those statements? Why are these statements so important? Statement by Caleb and Tebello.
They talk to the BMW. The BMW has been identified as being the vehicle that followed the deceased entourage from the airport. Now, the IO is tracing to find this BMW because it has been identified. And he gets it from the old couple. Now he has to go back as to, at the time of the incident, who owned it. Now, the couple said no, Caleb sold them to him. Then he gets to Caleb. Caleb, an applicant number 4 now, no, can explain. Now, number 4 does not know what Caleb said to the police. Hence, he demanded it. Get me the statement. Because this BMW is linked. I don't know if that is not interference, what can you call it, with the investigations. Even when you are not even arrested. Hence, we argue that him presenting himself to the investigating officers and offered to make a statement with his attorney was trying to shift the investigation from him. To say, but here's my honest explanation about the BMW. Because he knew that this BMW might get me into trouble. Your Worship, in finalizing what was said yesterday, we are living in a modern era where the views of the community about certain aspects should not be expected to be given in the manner that we knew before. I will make an example. Before the dawn of social media, people will come into a door outside courts about certain things. No, that person must not get bail and all of that. They will do that to express their opinions about a certain aspect. But community feels that I can show this in another way than to go to court and jump up and down. And I put my views out there in the social media so people must know. Now, one would expect, or one would argue and say, the presence on, let's take the old era. People are chanting outside, making a whole lot of noise. The court is sitting. No evidence is there in court to say there are people outside, but the court can hear the noise. The court adjourns. The court walks out of the building and see the placards. No one comes to court and show the placards in court. The court is going to take judicial notice that there's a noise outside. There are people with placards outside. Because the court is listening, the court is looking. And the court is entitled to say, I've been sitting in this court. I've been hearing noise. They must not get paid. They must not get paid. All of that. I walked out. I saw the placards. I took judicial notice of that. It does not have to be brought to court for the court to take judicial notice of that. Now look at the social media. Same thing. It's that it is another platform than the physical one that was used to. You can take judicial notice of what the people are saying out there. There's nothing stopping you from doing that. There's an outcry from the day this offense was committed, both locally and internationally. And the community is looking at this court to say, at the end of the day, can we have public confidence in this court to say, those that have alleged to commit these kind of offenses can easily be granted bail. We have to accept that we must move with times. People see no need to come with gumboots and stand outside court and make a lot of noise. They pick up their phones and talk and express their feelings and share their feelings. The issue of the cellular phone record of applicant number 4, rather the cell phone handset of applicant number 4. Your Worship, you were informed that a request was made to those representing applicant number 4 that he assist the police in the investigation by handing in his cellular phone, which was not found at the time when the police went to his house. Now, there's an allegation that the same police that are looking for the cell phone actually took it from the applicant's home. And the person who was leading the policeman to go and look for accused number 4 and actually engaged with the wife of accused number 4 is the investigating officer. The video footage will show that. They're even standing outside the gate, outside the door, talking. This is the same person who's looking for the cell phone, and you are told, no, the group took it. Strangely, after all this, there was a case opened with Applicant, and a list of papers, or a list of items allegedly stolen by the police is there. And was the level indicated as part of the things that have been stolen in the house. What?
So the cell phone that you are looking for, which cell phone you are saying applicant number 4 is refusing to hand over,
Yes.
is not listed as one of the stolen items,
Exactly.
despite the fact that he is saying that it was taken by the police.
By the police. Case is open with Applicant. Allegations of things stolen from the house. Cell phone is not indicated. And strange enough, after the refusal, we had to again apply further for section 205 to get the cell phone records of the applicant. 4. The phone, according to the records, is still active as we speak. And strange enough, it remained active, according to the records, at the area. Let me put it this way. Prior to the police arriving, there's a tower which this cell phone connects with when the accused is at his home. The cell phone record will show this is the tower. The police came and left everybody in the house. After they left, during the course of that day, the whole day, it's still connecting to the tower that it connects to when he's home. to show that the police did not take it. The cell phone record is here. Unfortunately, we got it after we have closed our case because we are following this cell phone. Now, where is the cell phone? Applicant number 4 alleges the police took it. We went to an extent of getting a cell phone record. The phone is active as of today. Is that not interference? And we know these days how much information one can obtain from a cell phone. Your Worship, in the attempt to shorten my submissions, Your Worship engaged me on the case against the applicants. I think I've summarized a lot, and a bit of our evidence is circumstantial and the other got direct evidence. But the combination of the two is so powerful that there's no way that your Worship can say, at the face of it, there's a strong case against the 5 applicants. Forgot just one thing about applicant number 2, Your Worship. On the interference. Somewhere in the state's affidavit is indicated about the instructions he gave when the firearms were returned back to destroy the evidence. Something is mentioned there about destroy this evidence.
Yes.
That is now instruction from number 2. And if you take that to the next month in Peria 53, where the IO says when it got to the scene where the Mercedes-Benz was dumped, there was Coca-Cola spread all over it, as well as there was an attempt to set it alight. There was matchsticks and all that evidence links as well, that case links as well to number 2, present before you, and the others. Now, if you follow what was uttered by accused number 2 in February, and what transpired when the Mercedes-Benz was abandoned, we have, further, stated in the affidavit that there's a voice note that was found in his cell phone about tracing who's informing the police somewhere in one of the paragraphs. He's trying to get the names of the people that are informing the police about them. Is there in the these are all conducts which are indicative of the likelihood of interference. Fortunately enough, Your Worship, the investigating officer in his affidavit dealt with each applicant, with each leg. All I can submit is Section 64 says, the interest of justice do not permit the release from detention of the accused where one or more of the following grounds are established. You don't need all 5 to be established. The minimum is 1. There's also 2 that you can. If it's established, the evidence is there. The previous conduct of the applicants prior to their arrest, during arrest, shows that some of the factors and
But
listed.
if the state or did not play open cards with the applicants, the state was not fair in that the state at the inception of the proceedings did not state what are the grounds of opposing bail. So the state has opened the net wider and waited until the evidence is given, and then the state is grabbing on straws.
Your Worship, from my recollection,
That is the argument that was raised.
we have to play the record because I remember him mentioning two: interference with witnesses and flight risk on the inception. But somebody saying I didn't mention it. I argued first what section 60 subsection 11 says to say, but there's no application before us. Why should I however, to mention a few, this is what I'm saying. Be that as it may, assuming the worst happened, I did not mention. They know what they are supposed to do is to use evidence to satisfy this court of the existence of exceptional circumstances.
But their application is frustrated if the state do not outline what the grounds are.
I'm coming there.
Please.
I'm coming. Now, that is the first line. The second line is they know what needs not to be established in terms of section 60. Point number 2. Point number 3, the state now gives an affidavit. This is it. Answer this. This is what we're saying. Here's the case against you. Here are our fears for your risk and everything. Al the alteram partem. Now you know. You were given a chance to reply. How much more can one be given an opportunity? And in the midst of all of that, the state stands up and says, we're trying to assist you. Also do this. Also use this evidence. Also do this. You can't rely on this evidence. We have been active enough to say this is how it's supposed to be done. But the bottom line is, when Exhibit G was given, every one of the applicants was given an opportunity to answer to it. And which they did. And the state, Your Worship would recall, requested the chance to say, but we have raised new facts. The court said, no. That's enough. We left it at that. There are certain things that they have raised that we have not responded to on their reply and affidavits. But a chance has been given, as well as a few, Your Worship, that they have raised. I might, because this was going to be my last point on this aspect. And I know my learned friends will want to reply, but I think we might also need another 5 minutes break.
5 minutes should be 5 minutes, please.
Thank you.
It's 11:53, 11:58. Apologies.
Where's my phone? On the aspect of 60D, Your Worship, I forgot something about the choose number 4. The issue of operating or having bodyguards who are not, or a security company, or a lack of a company that offers security services without being regulated by CIRA. That is a very serious offense. Your Worship, we picked up certain few things that were raised in the replying affidavit and realized that we are in a position to make submissions at this stage of the proceedings and not necessarily have to lead evidence in that regard. And we are of the view that there's no injustice on our side by the court, because these are issues that raised from the papers and can be argued from the bar. For example, if I take each I choose as I did initially, you'll find Exhibit H for Applicant 1 and 5. Where in paragraph 4.4, it is alleged that the state rely on the evidence of informers, which we disagree with, because in paragraph 4 of Exhibit G, the investigating officer clearly stated where he obtained this evidence from a number of sources. Ballistic experts, witness statements in terms of 204, cellular phone records and the analysis reports of those, bank records, statements in terms of 236, CCTV footages, vehicle tracker reports, and amongst others. There's no mention of informers for the evidence. On 4.8, it was argued that the court must think of whether to admit or not. I think the issue that was raised, the admissibility of certain evidence, of which the state informed this court that the state has given evidence that it has against the applicant. Instead of the applicant dealing with the evidence, the applicant chooses to shift the focus of this court to a trial court by saying, do not admit that evidence, do not admit that evidence, whereas it is evidence that is admissible in these proceedings. Your Worship did ask me about the grounds, which I have answered. We argued the issue of the DPP's affidavit in our heads, as well as at the time when we were opposing to its admissibility, to its admissibility. There's a misquotation of the DPP's affidavit on paragraph 27. I think the applicant is raising this on paragraph 4.18.
That is now Exhibit H.
Exhibit H, 4.18. He says, quoting the DPP's affidavit, cellular phone records were obtained for Spamandla Ngobo and compared with cellular phone records at the scene of the murders on the night in question. it was established that Spamandla Ngobo Mnanza has communicated with applicant 2, Lindane Zanzeli Ndimande, herein after referred to as Shisela, Siyabonga Kezani Ndimande Nxele, and Dave Malusi Ndimande MJ, prior to the matter. The cellular phone records of applicant 2, Shisela, Dave Ndimande, J, applicant 4, and Kwabeni, and applicant 1, Taban, were obtained, and they were also placed in the vicinity of Florida Road where the matters had taken place and at the time of the shooting. Now, it appears as if he is arguing, if I read the DPP's paragraph 22, Your Worship, talks about communication between Ngobo, Kwabeni, and Lindane on the night in question. Paragraph 27 of the DPP's affidavit speaks of the communication between Ngobo and applicant number 2, Shisela, Siyabonga Ndimande Nxele, and Dave Malusi Ndimande prior to the matter. The argument is that it seems as if we're placing Spamandla at the scene. We're not saying that. We're saying there was Spamandla's phone was picked up at the scene where the Mercedes-Benz was dumped. And following it up, now having established that this is the getaway vehicle, who bought that voucher? That's when we established this is the person. Who did this person communicate with? We established he communicated with others. When? What is the relevant period on the night in question? That's when we managed to say, now we have picked up other cell phone numbers of other role players. Who are we putting at the scene? We are not saying Spamandla communicated during the commission of the offense, but prior to that. The rest seems to talk about the DPP's affidavit, which I think I've made submissions enough. Now, the issue of applicant number 1 being granted bail by Mr. Singh seems to be one thing that has been raised. And I think I've argued that in our heads to say that we are not bound by that decision, and the facts and everything else are different. The issue of the cell phone record in relation to our case, I've argued that. The issue of the asthma, I think I've argued that as well. That might be all insofar as applicant 1 and 5 is concerned. If I can quickly go to applicant 3, Your Worship. And there's nothing more to add on applicant 3. I've argued about the change of the statement by applicant 5, then applicant 4. Your Worship, there's an issue about on Exhibit M for Mama, paragraph 19. There's allegation that another indication of this, that is now Mr. Pillay not being truthful to the court, is that one of the suspects who attempted to set the Mercedes-Benz Allied purchase airtime from a tuck shop a few meters from where the vehicle was abandoned. This honorable court is not informed as to the date upon which the Mercedes-Benz was allegedly attempted to be set, as well as the date upon which one of the suspects allegedly purchased the airtime. I don't know where applicant gets this, because on paragraph 24 of Exhibit G, 24.
Paragraph
24, Your Worship.
24.
On 6 March 2023, I was informed that the Mercedes-Benz used in the commission of the murder and attempted murder on Perea 53 was recovered near Kato Mena Informant Settlement. I attended the scene and established the following. So it's there.
Please.
Thank you. Paragraph, Exhibit M, paragraph 25. Pillay once again jumps to conclusions when he alleges that I gave instructions for the disposal of the vehicle, referring to the grey BMW. This is a distortion of the truth, that I did not dispose of it in the sense of wanting to hidden, as Pillay wants it to this court to confirm. But there are statements to this effect in the docket, and we have indicated that in our Exhibit G. Your Worship, I'm trying to make sense of the relevancy of, if anything, about how entry was gained in the house of applicant number 4 in this bail application. Nothing of substance as evidence linking him to the offense or to this bail application was found, so as to allege. I'm trying to make sense of the connection thereof. The state is saying, no, we entered as the policeman normally enters to come and look for a suspect. But much is made of it. Even the video footage is given. I'm trying to make sense of what is the relevancy in you deciding whether the bail should be granted or not. I fail to understand or get the connection of the two. Your Worship, much has been said about, on paragraph 28 or page 10 of Exhibit M, about Pillay saying there's an element of evidence suggesting offenses committed under gang-related activities. The state is collecting evidence to substantiate these charges. I think we have highlighted a few issues that suggest the following. And Ms. Gidding at some stage did indicate that the state is anticipating this and that and that. So far, there is an indication. It is the state that will have to decide at the conclusion, or at the stage where the state is of the view that the evidence is enough to substantiate those charges. But it is not for your concern, because we have not charged them with that at this stage. May I approach my colleague as well as my investigating officer to see if there's anything that they would love me to address on before I expose myself to the court for any questions that the court might want to ask. More than anything, Your Worship, I think on our Exhibit R, we have highlighted from the decided cases what you should consider as exceptional circumstances. I think that is clearly indicated from paragraph 10 of our heads up to paragraph 37, and they have raised numerous case law which in essence say one of a few, for example, Mazibugo's case say for the circumstances to qualify as sufficiently exceptional to justify the accused released on bail, it must be one which weighs exceptionally heavily in favor of the accused, thereby rendering the case for the release on bail exceptionally strong or compelling. Now, we indicated in our heads, Your Worship, I think on paragraph if you can just bear with me. There is one paragraph I'm looking for. Relating to personal circumstances. Sure, Your Worship will find this, but I think I've made submissions there of about the ordinary nature of the personal circumstances of the accused, not to be.
Well, I think you refer to Machebula there.
In Machebula there, Your Worship, yes, and there's a certain paragraph that where I summarize this. We even argued the issue of presumption of innocence, Your Worship, because there's case law in that regard. Yes, Machebula. It's one of those. Unless there's anything else, Your Worship, those will be the submissions by the state. Of course, in supplementing the heads of argument that have been drafted and handed in.
Okay, no, thank you.
Unless there's anything else, Your Worship.
No, there's nothing from my side.
Thank you.
Yes, I'll try the best I can to be concise and succinct in my reply to the state's submissions. First and foremost, Your Worship, my submission is correctly in my learned colleague submissions is the submission to the fact that some of the issues are pure trial related issues rather than for bail application. Having said that, Your Worship, my submission is, listening to my learned colleague submissions, it becomes more apparent as a day how easy during the trial proceedings to argue that the state case be brought down from that high level of theory to the practical level where matter matters, where there is allegation and then evidence. I'll demonstrate that in my reply, Your Worship. With regard to the charges, my learned colleague stated that the state may choose to put as many as the state can. And the court does not have a jurisdiction when it comes to the decision whether there is splitting or duplication. However, that submission confuses two things. Firstly, the admission with regard to the independence to prosecute on whatever charges is not being contested. My colleague is 100% right. But the problem here is, with the applicants shouldering a responsibility in terms of Matebula, in terms of Pulampula, in quite a number of cases, to exhibit and demonstrate to this court that the state case is subject to doubt and is non-existent. And Section 6011A saying that responsibility must be discharged on a balance of probabilities. Invariably, Your Worship, on the other side of the coin, if one side is made out of that responsibility, on the other side of the coin is the accountability. Can one shudder to think if the applicants before this court did not say anything about this quite long list of charges? As we are applying for bail and we are called upon, as the court correctly stated yesterday, that this is the game where questions are posed for answers. Unfortunately, some answers have to be questioned. Therefore, Your Worship, based on that, we have to say something about the duplication, about the splitting. Not for determination if there is splitting or duplication, but for determination whether or not, in line of the test ordained in these cases, is the state case not subject to doubt? Will the state be able to procure conviction on all these charges? Conspiracy to commit murder, 5 counts of attempted murder, money laundering, and so on and so forth. And there, with the allegation of theorization, you look at the answering affidavit of the state, particularly with the attempted murder counts, the state saying generally where there is a group of people, and then you look at the heads of argument talking about the human experience. I won't go back to the cases that we furnished this court as that form part of our submissions yesterday. The money laundering, other than saying with the papers in which the state has pleaded, no serious dispute of the 3 points exhibited and demonstrated in this court. The Tabashe and Globo decision, whether or not a possibility exists that I may misunderstood them. My humble submission, Your Worship, is that fortunately in these proceedings we have got those cases before you. The only thing I can do in that regard is to give the court the approach as ordained by Ananias Nin. We don't see things as they are, we see things as we are. So based on the fact that we are on the defense side and the state is on that side, the extent to which that philosophy can affect our submission in this court. However, with the correctness of the submissions that I made yesterday, I stand by those. Your Worship, with regard to joint possession, the issue of the duplication, the state submitted to what degree and extent the state will place reliance on R versus Tebello. Then if we may have a pregnant pause for a moment, Your Worship. You have got the state talking about the inferences. We have got the allegation of the informers in this case. The allegation of informers, to what extent can one say that evidence has been presented in this court? This court ought to take it as an agreed fact. Yes, out of the 4 facts. Take it as an agreed fact. You look at the accused. Accused number 1. Mkwanazi says, initially, the investigating officer was so frank with the court, telling the other learned magistrate, I had to interview the parents and the siblings. And accused number 1 saying, at the bottom of my heart burns this unquenchable desire. Why is Mr. Pillay not talking to my parents and the siblings this time around? This morning, you hear the submission by my learned colleague from the state saying, that name can't be disclosed. Fine. You have got the allegation of eNCA. This court posed a very direct question. No affidavits confirming that he couldn't be found. He was disappearing like a morning mist. Again, allegation he was no longer staying there, staying in eNCA. Why no affidavit from a person deposing that this is a fact? Again, non-disclosure by the state. So, Your Worship, it is common cause in these proceedings. If the state is saying great deal of reliance will be placed upon inferential reasoning, assuming there is a conviction, we all know. Once there is conviction and the judgment is having its accent on the fact that the evidence was circumstantial, inferential reasoning, does the court refuse leave to appeal under those circumstances on the basis that another court adopting a different approach, overemphasizing the facts underemphasized by the court may arrive? It verily grants the leave to appeal. Your Worship, the delays. If Your Worship, okay, let me put it this way. The Snyder's case, my colleague has correctly submitted. But Your Worship, the benefit one has in these proceedings is, with this honorable court, with so many years of experience on the bench, there has been once a circular from the late National Commissioner Jackie Selepi, so clear. You arrest to prosecute. You do not arrest to investigate. And if I make reference to that, Your Worship, the court may bear with me. Your Worship, if I may draw the attention of the court to the decision of State versus M, 2000, Volume 1, SACR 484W, in terms of which the court stated as follows. Generally speaking, judicial notice will be taken of facts that were either so notorious as to be incapable of disputes among reasonably informed and educated people, or which were capable of immediate and accurate demonstration by resort of sources of indisputable accuracy. Your Worship, it's common cause between the parties. Incident arose in February 2023, and we are now in April 2024. Therefore, non-compliance with the late Jackie Selepi, you arrest to prosecute, from the submission by my learned colleague, it is clear the setting of the matter down for trial in this matter is still far away in the future. I will demonstrate that as I proceed, Your Worship. I know lawyers are not good when it comes to figures. When this court posed a question how long the investigation will take, it's very interesting because yesterday the defense was called upon to explain on etymology front. The investigation is advanced, but not where does the defense take it that the investigation are incomplete. It is interesting that my colleague for the state had to indicate if the question is posed, if judgment were to be handed down in this matter, can at the drop of the hat the state say next month the matter is being set down for trial? Though the court's question was short and the answer by the state was long, but eventually one was able to decipher some 5 months there. Then another critical point, which makes the application so profound by the applicants that they've proven beyond reasonable doubt, not even on a standard that is required of them, why they are capable and suitable candidates for the release on bail. Your Worship, if one reads my heads of argument, reading the papers, the pleadings before this court, my heads of argument exhibit M, page 7. Your Worship, you can see the difficulty I was having with my instructing attorneys. Reading the papers, trying to establish, will the extradition be an issue here? I had to resort to that case by colleagues in Sonke Gender Justice Network versus Malema, wherein colleagues considered the words of the author Samuel Butler, 1835-1902, that words are nothing, words are the clothes that the thoughts wear, only the clothes. Then I explained why we're to rely there. As we are going through the state papers, we were asking ourselves, then today, my learned colleague is making submission about the extradition. My learned colleague, when he submits in this court, he says, with regard to the extradition process, attempts will be made that is sorted out as soon as possible. That was the submission. However, Your Worship, at a practical level, the last extradition I did with my colleague, Mr. Volmarans, in Mpangeni, before the magistrate, Mr. Nchangas, I think it took 2 to 3 years. That extradition, because with the extradition we've got one problem. First, we have to get the alleged fugitive, if he consents to the process. If he consents, it becomes quicker because the magistrate will break the seal of the application papers, will make an order to surrender with the specific order that subject to appeal and so on and so forth, and then the fugitive will also waive those rights to appeal and so on and so forth. In my matter with Mr. Volmarans, the fugitive waived that right to challenge the extradition to UK, to appeal the decision of Mr. Jangas in Nepal. Nevertheless, it took, I think, between 2.5 years or 3 years. Then, in paragraph 15 of my heads of argument, I state as follows. In actual fact, the Extradition Act provides, section 4.1, subject to the terms of any extradition agreement and any request for the surrender of any person to a foreign state shall be made to the minister by a person recognized by the minister as a diplomatic or consular representative of that state, or by any minister of that state communicating with the minister through diplomatic channels existing between the Republic and as such. That is the process that causes the delay. As a result, Your Worship, because of the recognition of that delay, what would the state do allowed by the international conventions? it's then that we see that DPP affidavit in these proceedings. The state will draft a request for a provisional arrest, saying, in the light of the fact that the possibility of a delay between the requested country and the requesting country to have the fugitive brought back to first justice, can they not be provisionally arrested? That is why the requested country will first receive the provisional arrest papers before receiving the extradition papers. It's a pity in this matter there is that confusion, because in the meter it's as if what is being dealt with that side is extradition, whereas as far as I'm following it, is still the provisional arrest of the fugitive. So, Your Worship, which means that submission that...
The execution itself has not started yet.
Pardon?
In other words, according to your understanding and following, the extradition process has not started as yet.
Your Worship, I think 2 or 3 weeks ago, I saw the Minister of Justice, Mr. Lamula, say he signed the papers. From there, they should go to the International Relations Minister. From there to the Ambassador of the requested country. From there to the Minister of International Affairs in that country. From there to the Minister of Justice in that country. From the Minister of Justice to the Prosecuting Authority in that country. And then, Your Worship, with regard to the submissions that are being made today, it is as clear as a day that the intention of the state is to prosecute these accused jointly with the fugitives who are in Swaziland. That came out clear today as my colleague is addressing. The decision whether or not to separate the prosecution, it would appear that that is in ice. It is not a plan A, the way I heard the state addressing. It is on that basis, Worship, I'm submitting that. That process has to be looked at in a bigger scheme of things, as it touches on the accused's right to a speedy trial in terms of Section 35 of the Constitution, as it is loosely translated that justice delayed is justice denied. That is why it had to be brought to the attention of this court as an additional reason that this process on its own will put a spanner which will transgress the accused's right in terms of the Constitution. It's common cause that the preamble to the Constitution confirms everybody to have a right, and those rights to be protected, promoted, fulfilled, and protected. I think 4 years. So it is on that basis, Your Worship. Your Worship, my colleague for the state raised a very interesting point. It's a point that confirms how difficult it will be to separate the prosecution of these applicants before court from the alleged fugitive in Swaziland. Among other things, when I was listening to him making those submissions, the variables and modalities around that aspect, my colleague for the state raised something that is sensible, that among other things, to consider the fact that will it be fair for witnesses to testify twice in the same matter? Which persuades strongly for plan A, that the decision is for the joint prosecution. Your Worship, and then we look at the evidence as one is sitting. In this matter, Your Worship, we were so fortunate because before even the trial started, the DPP's affidavit, after we started our presentation, it was out, you could see what evidence is there. And then the court is asking a direct evidence. What eyewitnesses in the legal sense are there for the state? I battled to get an answer from my colleague. I battled to get an answer from my colleague. I ended up recording as follows. One will identify one accused who is not here in court. One will identify the second shooter. No umbilical connection to the applicants before court. And then the other aspects that happened to play itself out during those submissions. Then my colleague addressed the court about the scientific evidence that the state will be relying upon. As I was listening to the submission regarding the scientific evidence, at a later stage, the difficulty attended upon even presenting the video footage. It's a security point at the airport, Your Worship, King Shaka Airport. If you make an allegation about the security point, invariably, that evidence ought to be there. I did a case where at a garage, they couldn't find a video footage. Unfortunately, I was for the defense. Client happy. 7-8 months later, I was called from the transversal server in Cape Town. They were able to retrieve it. Boom. We're not talking about a small entity, we're talking about King Shaka Airport. Another difficulty one is finding here, when the terminology of scientific evidence is spoken about, no details. I indicated, Your Worship, yesterday, we don't have a luxury of leaving things unexplained. It's unfortunate that the state got away with it here. What makes it scientific? What is scientificity about it? Because we are already, which forensic aspect we have to prepare ourselves with, because of the view that we are innocent, will challenge this evidence. We did not get that, and then R versus the plumb. The scientific evidence and then R versus the plumb. And Your Worship, with R versus the plumb, whether or not the state will be able to satisfy the trial court about meeting the two cardinal rules of logic as ordained by Water Mayor AJ years ago, one can be the case. How if there's proliferation of inferences from these facts one can draw? Because as I'm sitting here, I see a number of inferences playing themselves out in court. I mean, in my mind. The court asks the state, is there evidence of a contract killing? That is a serious allegation to make. Again, inferential reasoning, circumstances, and so on and so forth. My humble submission is that submission will have to be approached with great circumspection in the light of the fact that there is allegation of informers in this matter. If there is allegation of informers and particularity cannot come out clearly, and there is no indication that it's the person who will testify by the name will be withheld, it becomes something for caution to be exercised for. Your Worship, the state can easily say, we've got this person will testify, is available to testify. However, if the matter will go to the High Court, 1443 of the Criminal Procedure Act entitles us not to disclose the name, disentitles the defense from knowing the name. That has not happened. Your Worship, the rudimentary principle with application proceedings, your case must be pleaded in the papers. As I'm listening to my colleague, quite a lot came out, but is not pleaded in the state case. I will mention quite a few in the interest of time, just to make an example, the possible time duration before matter is set down. In the founding affidavit, we are alleging it will take time. The extradition decision to prosecute jointly or keep in abeyance as alternative B, I can call it that way, because I couldn't get it clear, the theory around that as to what stage will alternative B be resorted to. That one wasn't clear. Your Worship, the issue of the exhibit that is before this court, KP5. KP5, as you browse through it, I understand, Your Worship, that with bail application hearsay evidence is admissible. But other than the submission from the bar, what evidence does this honorable court have? Giving these details, it talks about Otilwane. If you live in KZN, you know Otilwane is in KZN, in Mpangen. You look at accused number 1's residential address is Amadwaleni in Mtuba. How does one draw the connect between the two? And then the account, my colleague correctly submitted, we live in a digital age. Hearsay evidence that is admissible. At least to give this court a helicopter view of whose account is this that is before this court in respect of KP5. I understand the interpretation of the message that ought to have been part of the pleadings by the state if the correctness and the truthfulness of the message was to be argued about. You look at the message, it talks about the Otilwane area. Coincidentally, greatly, accused number 1 is in the pictures. However, him being in the pictures, one cannot be oblivious of the fact that before this court he has presented the proficiency certificates, the competency certificates to hold any kind of firearms, except the license that he has, that it's that of a handgun instead of a rifle. But in the finding, a true dimension of that KP5 ought to be made. If you make it, in the absence of this conspicuously, in the absence of this very significant information, even if hearsay evidence is admissible, in law now, to what extent would one attach probative value to it? Your Worship, one ought not to lose sight of the fact that accused 1 is concerned. In the other bail application, the investigating officer, who knows, probably to whip up the emotions, he talked about accused number 1's role to bring Moti in the other bail application before the learned magistrate, saying, again in this matter, the allegation of Moti was being made that something. And frustratingly, as you browse through the papers, you don't find even a basis upon which that conclusion is being reached that is Moti. I'm quite an old man now, but if you were to ask me, is this Moti or not, it will take me, that's what we talk about, the preconceived ideas, which in law must be validated by empirical evidence, by evidence. Your Worship, this court posed a very important question to the state. The explanation of the constitutional rights to accused number 1. Your Worship, I do not want to go back in history in that post-constitutional liberal democracy. Any evidence obtained by the police, whether there is violation of rights or whatever, it was admissible. Post-constitutional liberal democracy, these 3 categories of people become immediately entitled to the rights. The arrested person, the detained person, the accused person. You have got the affidavit of the investigating officer saying, upon arrest, he was asked about where he is living now because he's no longer living at home. Therefore, is the submission correct if the submission is to the effect that he was not bestowed upon the constitutional rights at that stage? My humble submission, Your Worship, is a sounding no. He was entitled to those rights. Then, if those rights were never explained to him in the world of law, in the constitutional society, what does one make of that? It's against that background that it had to make its way into the submissions on behalf of the applicant. The issue of accused applicant number 5, the state saying he was in Swaziland based on the bank card. It's evidence under oath by applicant number 5 that his bank card is loaded onto his cell phone. It is his evidence under oath that his cell phone happened to, though he can't remember, to be in possession of one of the arrestees. He has taken the court into full confidence to account for the use of his visual card in Eswatini. You have got the official state document, i.e. the passport. In the state submission, it is as clean as a whistle. No endorsement, no stamp. You have got applicant number 5 explaining why the stamp would not be there. He says it's because I was not in Eswatini. The explanation of anything else, it has to be pleaded. How the visual cards works and so on and so forth, instead of the submission from the bar. I'm still none the wiser when it comes to, as I keep on troubling sometimes my family, my instructing attorneys. Your Worship, the element of threat that was administered to accused number 5, according to his evidence, his mother calling him, saying, "Here the police." He says the police are saying, "We are at your homestead and we see there is a kraal here. We want you. Should you not come? We have already pointed out where your grave will be." Then you have got the submission by the state. Is the state denying the threat or is the state accepting the threat? Because at a human personal level, it's either you're pregnant or not pregnant. You can't be both. State says can't deny threat by police. The state denies the threats by the police. At the very same time, the state is saying the logic dictates that could possibly have been an inducement to have brought pressure to bear upon him to gravitate to approach his lawyer so as to hand himself over to the police. It can be, it's either or. It's either or, Your Worship. The very same logic, I submit it's a non-secret. The premise and the conclusion never agree. They are not in harmony. It's illogical. Accused number, a finding ought to be made. Applicant number 5 presented himself to the police after the call voluntarily without being pushed. Instead, after consultation with his lawyer. The submission to the effect that none of the accused initially divulged the information for having worked with or for applicant number 4. That submission should not be decontextualized. Reason why I'm saying this, Your Worship, we've got my colleague for the state again there. Did he disclose the reasons? Did he not? I heard him initially saying no, he stated about the state witnesses. But my humble submission, Your Worship, is I was watching the proceedings at home. The court has got the benefit of the record, whether or not at the inception of the proceedings, when the instructing attorney, Mr. Dlamini, extended the request to the state to disclose, if the state disclosed. And it is against that background, Your Worship, that there were a little bit of glitches in this matter because of the answering, the opposing, the replying, and so on and so forth. Hence, one ought not be confused why there will be a suggestion of new things coming out, because literally it's like one is changing a car tire while the car is in the highway at 120 kilometers per hour. So the issue of them, and what is important, Your Worship, if they make a disclosure what those payments were for, applicant number 1 says 100,000 rand was for the work done for applicant number 4. However, there is an additional 33,000 rand that had to be deposited into my wife's account for ECPED. Is it in dispute that applicant number 1 happily got married in February 2023? That is not an issue. That is not being disputed. And you look how applicant number 5 gave the identity of the transaction. He says the wedding things. And applicant number 1 is explaining by wedding things what exactly is that, based on the fact that if it is his responsibility to adduce evidence, as the state has stated, on the other side of the coin, he ought to account, is the accountability. It is on that basis of accountability, Your Worship. And then the last but one, it doesn't make sense, they all get equal payment. It's common cause accused number 3 never got any payment. The views of the community. Your Worship, I won't repeat that point, other than making reference to the decisions that I've stated, Zuma and Diwani decision, and the emphasis that those judges placed when it comes to how the approach should be. I think the issue of the social media, whether or not that should, I accept, we live in a digital space. At a time when Brett Cable met his demise, there was a book, Killing the Brett Cable, and as this case is proceeding, I also bought a book last week. I'm on page 136 or 137. That's the kind of life we live, we cannot deny. However, the humble request one would make is the adoption of the principles as laid down in those cases that the court, that are before this court. In conclusion, Your Worship, there is this rhyme. Will they stand trial? The answer is yes. Will they interfere with witnesses? No witnesses are known to them, no. Will they comply with bail condition? Yes. Should they default in respect of bail conditions? Will arrest be difficult? No. Personal circumstances. Do they exhibit ties with families and community? The answer is yes. Cumulatively, what does this mean? Exceptional circumstances, that it is in the interest of justice that they be released on bail. Obviously, with the conditions and the amount, that is the issue that falls squarely within the discretion of this honorable court. That is all, Your Worship, not unless there are issues that would require clarity or require clarity.
No, I think everything is on track.
I'm indebted to the court for the information.
Before you rise, Mr. Volmerans, I see it's almost 1 o'clock. Can we agree that we sit until we finish?
I'm more than happy to do that.
Anyone? Any objection?
None.
No objection.
Thank you. Thank you, Mr. Volmerans.
Thank you, Your Worship. Your Worship, again,
I'll give Mr. Taylor for 5 minutes.
So there was an objection, but
No objection. I'm just stepping out, Your Worship. Mr. Tora is here. Yes.
I'll assume this situation.
Your Worship, again, I will endeavor to be as brief as I can. Your Worship, my learned friend for the state has gone on and on about the onus and what the defense must prove. Yes, but the defense are not required to prove the state's case. The defense are not required to even assist the state in their endeavors to prosecute the accused. That is not the purpose. And then there is reference continually to the proceedings. Your Worship, with the greatest of respect to my learned friend, these are not proceedings. These this is an application. There are rules that govern applications. They don't differ from one moment to the next. Now, my learned friend has referred to section 6011B C. Now, if you read that section does mention the words subsequent proceedings, but these are not proceedings. This is a bail application. It is not proceedings. These are not criminal proceedings. So, to go and grab a document from another bail application and attach it doesn't make it admissible. That's the first point. The second point is, if you read section 6011B subsection C, it refers to the admissibility at trial. That whole subsection deals with trials. It doesn't deal with bail applications, except to say that the bail application is admissible at trial, provided certain criteria are met. So, to merely submit that, yeah, no, we can go and fetch it. Then when we objected, then we were subjected to reference to section 235. Now, section 235 is quite clear. It talks about the record, not the part heard record or a portion of the record. And what was handed to your worship was not the record. Because where is the typed evidence? Where is the typed portion of that so-called record? It's missing. So it can't be admissible. And any document attached to, no matter whether it's page 1 has been certified or not, it's irrelevant because it's not the entire record. And you can't use a portion of a record to prove something. You've got to prove the whole record. And that has not been done. So any reference to any affidavit made by applicant 2 and that record is inadmissible in my opinion. My learned friend has said that he has made every endeavor to assist the defense. Well, Your Worship, I beg to differ. Because if you look at our affidavit, where we have tried to reference Elaine Harrison's affidavit, we were ordered to redact every mention of her. And that's how the affidavit went in. Now, how is that assisting us? Knowing that it is actually admissible. What were the state trying to hide? One wonders. Eventually, when my learned friend for accused 1 and 5 raised the question and brought the application, did Your Worship say it's provisionally? But by then, the horse had bolted. Our affidavit was already redacted. All of that evidence was expunged. Just to reiterate one aspect that my learned friend raised, and it goes back all the way to 1976, Estate versus Bennett, where the police are specifically told, you don't arrest in order to investigate. Your Worship, much is made about the word risk and whether the 5 accused are at risk. Every single person in this country, yourself, myself, my colleagues sitting around this table, we're all at risk. And as His Lordship Maggot J, and I've quoted the case in my head, well, not that particular portion, but the onus is on the police to protect us. We don't have to protect ourselves. And if the police don't want to do their job, that's their outlook, not ours. Your Worship, a lot has been made of the fact that Applicant 2 has stated two different amounts. Well, as Your Worship rightly pointed out, and I'm not going to elaborate on that, circumstances change. When that affidavit was drafted back in 2023, but only came before the court in 2024, then circumstances changed and incomes have changed. As my learned friend for accused 4 says, one day advocates are rich, the next day they're poor. So income is flexible. Your Worship, the fact that he is absent from his business is indicative of the prejudice that he is suffering, he and his family. So it cannot be held against him that he says, well, then my income was so much, now it's so much. Your Worship, I've made a note here, hindsight is 20/20 vision, because my learned friend says, this should have happened, that should have happened, this, they should have done this. Yes, hindsight is 20/20 vision. We all know that, and that's what he's trying to impute on the applicants. Your Worship, my learned friend for Hughes 115 touched briefly on it, and I'm not going to reiterate it, except to say that a lot of what my learned friend for the state said amounted to evidence from the bar, because it's not substantiated by Exhibit G. I am not going to preach to the court because the court has the ability to distinguish fact from fiction. And I call the evidence from the bar, that is fiction. Your Worship, it is reprehensible of the state, and again I refer to documents which I submit are inadmissible, to try and slip in through the back door evidence which should only be dealt with by the trial court, and which quite clearly, as stated, is going to be challenged, to try and slip it in. It is significant that Mr. Pillay says at paragraph 185 of his affidavit that the second applicant was cooperative. We will stop there, because the word cooperative is the important word. He didn't try and give them a runaround. He didn't try and do anything like that. And contrary to what Mr. Pillay says that they searched long and hard. What did they do? Because they immediately went from his home here to Gauteng and arrested him at Motsoane Mall, which is in Soweto, where millions of people live. And yet they were able to pick him up. Amazing. Your Worship, one aspect, and again, hindsight 2020 vision, we are not informed by the state. We are told about this message on a phone. We're not told who the conversation was between. 2 names are mentioned, but how do we know? Who is Mr.? We don't know. We're not given any indication. The police know, but they won't tell us who it is. And how do we know that they were even talking about this case or any other case? Because there are no specifics given, Your Worship. So how does that amount to interference? It doesn't. And then again I refer to the State versus Bennett, the 1976 case, where it says even though there is a likelihood of interference, until it actually happens, bail should be granted subject to conditions. And if there then becomes interference, the state can always apply for a warrant and arrest the accused.
I don't know whether you have a copy with you. Does it say so the damage should be done first before anything can be done?
So, Your Worship, could you hear?
I say you're saying it says interference even though there is suggestion.
It's in the head note, Your Worship, of the Bennett case.
You don't happen to have it with you.
I unfortunately didn't bring my bundle of cases with me.
I'm trying to see logic in this. Wait until the damage is done before anything is
Your Worship, I'm just saying what the Judge Force said.
yeah, but that's why I'm saying I'm trying to look at the logic.
Yeah. Your Worship, I don't question the judges and their logic.
Okay, proceed.
Your Worship, finally, the opinions of the investigating officer without tangible evidence is irrelevant. And for that reason, Your Worship, I ask that the court ignore all opinions given by the investigator and his team, because we don't know which one of his team came up with these. Might be him, might be one of the others. We don't know. So, Your Worship, those are my submissions, unless Your Worship wishes to hear me on any other aspect.
No, thank you.
Thank you, Your Worship.
Ms. Gilling?
There are not very many things that have been brought up by the state in their address. Your Worship, just to touch on the submission by the state in respect of the case law supporting a person being charged with possession of a firearm and murder where the firearm was not recovered. It is poignant to note that in that scenario, the accused that was convicted was seen pulling the trigger and firing the shots. It's very unlike my client's scenario where he's not even placed on the scene, Your Worship. I don't wish to supplement my heads with my address now, Your Worship. I'm just going to touch on some submissions that the State has made, additional to their address, Your Worship. Your Worship, the evidence, no, not the evidence. Now, the evidence of the State is contained in its affidavits, and ours is contained in ours. However, as my colleagues have pointed out, the State seemed to endeavour to have led a little bit or sneak a little bit of evidence in while it was doing its address orally, Your Worship. Nonetheless, a submission was made by my learned friend that the second shooter, because there were allegedly two shooters, the second shooter was not identified by a witness. The first shooter was identified as being one of the accused persons that are arrested in Eswatini, and they're not part of these proceedings. So for us, there is a second shooter for us during our bail application that has not been identified. So it might or might not be one of the 5 accused before court. That's by, say, admission from the State side to say there is a second shooter, yes, but that shooter has not been identified. So who the persons before court at this point in time, it cannot be said that there was an identification of a shooter. It could be the second accused in Eswatini, the second shooter. It could be a person out there that does not form part of proceedings at all between Eswatini and South Africa, Your Worship. Your Worship, in respect of payment, the State was asked to just respond on payment to my client, applicant number 3. The State then chose to rectify that lacuna in its case in opposition of bail to say, well, they suspect he might have received cash and he's developing homes with us. Your Worship, that is not evidence before court, Your Worship. It is a little bit slid in from the side, and the defence is asking the court to disregard these submissions. Every time the State is asked the question, the State, instead of addressing the question, slipped in a little bit more evidence, Your Worship, as if it were their opportunity to do so, Your Worship. In any event, it seems improbable that you are going to do housing developments with 133,000, Your Worship. It's the first time we've heard about this cash exchanging hands. It was unfortunate that the State had said there is intelligence or there is information. They're still checking, but yet they do refer to my client as a person that is living in such poor conditions that it's almost like he has nothing to lose. It's a room without any belongings. They could have brought it up at that stage, Your Worship. It was never brought up that my client is a person who's now property developer of 133,000 rand cash he received. It's utter nonsense. Your Worship, in respect of, the court can bear with me for 1 second and I can be brief. In respect of the submission that my client and the court had asked me questions whether my client shows a propensity to commit offences that are serious, such as these, referring to the pending cases, Your Worship. The State had indicated in its address that applicant 3 is not supposed to be on scene. His role is to not be on scene but supply the machinery, that would be vehicles and firearms. And then he goes further to say he's not placed at the crime scene, and the doctrine of common purpose, if it can be proved, will then sustain. But he also referred to the pattern that follows, which sort of implies, perhaps, that the other cases that are being referred to, my client is also not placed on the scene as a shooter, Your Worship. However, we've not gone into the merits of those cases, but to go further into these cases, to close holes, is putting the State in a precarious position and assisting the court in saying, what are you saying about applicant number 3? He's not a taxi owner. He's a person of very, very meagre means. To say he's the organizer, the collector of firearms after the incident. My client was in hospital after the incident. In respect of the Mercedes-Benz that my client allegedly had delivered, that was robbed sometime early 2023, Your Worship, my client is not charged with the theft of that vehicle. There's another person charged with that theft of that vehicle, and that matter that matter, I think, had come before court for an adjournment and will be coming before court as well. That is a Mercedes-Benz, not my client, and not in this matter. So I think this allegation that my client was at some of these offences, all the alleged offences, we're going back to the age of 19. He's now 21, Your Worship, looking at all the pending cases. It is a bit improbable to believe that a young man of 19 would be trusted by all these taxi associations and taxi owners to be the collector of firearms, distributor of firearms, collector of firearms after the incident, collector of vehicles, and off he goes again, Your Worship. That is highly improbable, Your Worship. Your Worship, in respect of the state's reference to the Motsoane case, in respect of prior agreement and active association, possibly we have not got a copy of this case. It was just brought to the court's attention. I agree that if the court said agreement, meaning prior agreement now, conspiracy, should not include a wider agreement. And I agree with that, that if the court held that, I do agree with that. And this court, so the state says, is it can be including a wider agreement if active association is proved. Your Worship, in this regard, meaning prior bail applications, yes, he washes vehicles and so on and so forth. He lives in the area, he knows these taxi associations, he washes vehicles for money for them, so he knows of them. He's not associated with them as an owner. So could it be that he was rounded up with the usual suspects? I don't know, but the benefits might lie with my client then in that regard of why was he rounded up in the first place, Your Worship. Your Worship, the issue about public outcry, that I think my learned friend is trying to move on something new, something he did not bring into his papers would be public outcry. He did not really extrapolate on that in his papers, or in the, I would say the investigating officer's papers, Your Worship, and the heads of argument, but he referred to social media coming out strong in respect of bail shouldn't be denied and so on and so forth. However, there's nothing brought into evidence to assist the court to see this. There's no captions or screenshots that have been attached to any affidavit to say to court, this is what we're looking at now. And the public are angry and they're demanding further detention, Your Worship. So that should be disregarded in that sense, Your Worship. Your Worship, I think that is all I needed to address. That was new. Thank you, Your Worship. Thank you.
Yes, Your Worship, please. So, Your Worship, in order to address some of the submissions made by the state, it's really necessary to go back to the beginning. Now, the disadvantage, as Your Worship knows, of any applicant in a bail application is he doesn't have access to the docket. And the law essentially says, show me yours, but we're not going to show you ours. So what we have in applicant number 4 is an applicant who has been proactive. Now, how do you challenge what the state is going to say in your found-in affidavit without trying to get some insight into what the state is going to say? For the most part, an accused can't, because he doesn't have access to the docket. Except in this case, and it was on the news. There was the application in Swaziland for the extradition of 2 suspects to be joined to this case. Now, these accused are arrested, and it's all over the news. There is this application. In fact, I think even the Commissioner of Police said he's disappointed with the counterparts in Swaziland for releasing everything to the media. So, in order to be proactive, in order to take the fight to the state and say, right, we're going to address each and every of your allegations because we've got nothing to do with it. The instruction was for my attorney to drive to Swaziland to get hold of the extradition papers, because any party requiring the extradition of any individual has to set out the basis of the case against that person. And that then gave this applicant insight into the case that he needs to meet. Now, I would surmise that that is why the state wasn't very happy with it, why they didn't want it included in this case, because it also serves to restrict what the investigating officer is going to say. He can't say anything he wants without any of us being able to check and say, well, yes it is, no it isn't, until we allowed access to the docket when the matter is trial ready. And then following that objection, Your Worship ruled for various reasons initially that it wasn't admissible, and those aspects in the applicant's affidavit had to then be redacted. Now, the relevance of what I'm saying to Your Worship comes down to the 800,000 rand. And the state saying with some glee, well, how would they have known about the 800,000 rand, etc.? Can I take Your Worship to the applicant number 4's found-in affidavit, paragraph 92. Because let's not forget, Your Worship, the state is trying to say we kept quiet about the 800,000 rand. We didn't put up bank statements for the 800,000 rand. That was their submission. But let's look paragraph 92. And let us not forget that this was deposed to on the 19th of March. Paragraph 92 reads, I shall now deal with the allegation, certainly as stated in the media, that I received 800,000 rand the day that the deceased was killed, and that I transferred 133,000 rand to Linda Kuchle in Demonde. So it was already set out there. It was no secret, like the state would want Your Worship to believe. They're hiding. They didn't put up their bank records. hiding the fact that period because it's the 800,000 rand. No, it was already set out in the applicant's founding affidavit. Then paragraph 93. The 803,000 rand was paid to me from a reputable company whom I've done business with before. In fact, our business relationship goes back as early as 3 years back. Now, that really deals with the state's submission that applicant number 4 is trying to hide something in respect of not putting up banking records. And that is why we say it's common cause. It was out there in the media. It is, of course, my learned friend's words. We live in a digital age. Now, that really...
Where is the statement for December up to March? December 2020?
Well, Your Worship,
23 to March.
if it's not there, it's not there.
But the question is where?
Well, I would suppose with the banks it can be accessed by the police. But the importance of it is not that the fact that there are no bank records. It related to the 800,000 rand. That was the silver bullet that the state was looking for. That is, as I understand the state's submissions, as to we were attempting to hide this. But no, there was a full disclosure from the onset.
You cannot say it's a full disclosure when there is a bank statement or part of the bank statement that is missing, and you cannot answer to the question, where is it?
I hear Your Worship. I'm referring to full disclosure in respect of the 800,000 rand, which forms the bedrock of linking accused number 4. And I stand by that submission respectfully, Your Worship. Now, on that part, often it is not what is said, but it is what is not said. Your Worship, and even though Your Worship probed my learned friend, no mention made of Mfundo Glaba, the man who paid the money to applicant number 4. What did the state say in relation to that? Let's have a look. The affidavit of the investigating officer, page 25, I think it is, Your Worship, yes, paragraph 71. The money was transferred from a bank account of the company. I'm sorry. Yes.
This time you're coming up well with the pages and the paragraph. Thank you, Mr. Jones.
I'm happy to hear that, Your Worship. The money was Is Your Worship with me?
Yes, I'm with you. Thank you.
The money was transferred from a bank account of the company Bright Circle Pty Ltd. According to the company records, Mr. Sidney Mfunda Glaba is the sole director of this company. When the money was transferred, a reference was used as consult. This, we are of the view, was done to disguise the nature of the funds, as same is viewed to be payment for the shooting. Yet the person who paid for the shooting, once again, isn't an accused yet. Your Worship has not been addressed by the state on that aspect. And I would submit he's not here because the state is scared. For reasons only known to them, they are scared to make this arrest. Now, the reason why they're scared is because there's no evidence, because it is exactly that. One reputable businessman paying another reputable businessman for work done. The problem that the state has, and that they want to make our problem, is as long as our answers do not suit them, as long as our answers do not fit in with their preconceived narrative, they will say, we're not happy with that answer. But quite frankly, it's not for them to be happy with. It is Your Worship. Given the information that applicant number 4 has been able to search for, has been able to obtain, he's addressed everything. Now, I stand by my learned colleagues and their submissions, and I agree particularly, my learned friend in his address gave what I would say a fair amount of evidence. Now, yesterday, when I addressed Your Worship kept me on my toes. You say this, where did you deal with it? What paragraph? What page? And I'm sure that when Your Worship considers all of the evidence and our addresses, Your Worship will then look at what my learned friend said today and say, fine, what paragraph do I find that in the State's affidavit? And I'm going to submit to Your Worship that much of what was said today, Your Worship will not find, because it's not in the affidavit. And I'd like then to refer Your Worship to this decision. It is Maboho, it's spelt M-A-B-O-H-O, so it's Maboho T, and 117, as in the number, 117, related cases versus the Minister of Home Affairs. The citation is 2011 ZA LM PHC 4, and it deals with the question of argument. Your Worship will find it at page 7 of the judgment. Argument is not evidence, and it is not given under oath. It is merely a persuasive comment made by the parties or legal representatives with regard to questions of fact or law. Argument does not constitute evidence and cannot replace evidence. That, Your Worship, deals with everything my learned friend has said to Your Worship today that is not in their affidavit, and that's a lot. Then, Your Worship, just various aspects that were raised. Now, my learned friend has made mention of the reference relating to the payment following applicant number 4 receiving the 800,000 rand. Words like shares, wedding, and so forth. Well, that is what is there. There's nothing illegal in that. There's nothing concealing in that. You can put any reference you want. Could be your share for the work. Now, Your Worship will also recall that from the onset, in relation to the averment that applicant number 4 was at the airport, that he paid for parking, that he was in the BMW, from the onset, applicant number 4 said, and it's in the affidavit, the airport is a national key point. It has CCTV coverage. I challenge the state to produce CCTV footage of me in the vehicle. Today the state answered that, and the answer was, we don't have any. Can't see who it is. Alternatively, and that's only from the toll road, the other part of the answer was, well, the airport doesn't keep it for that length of time. Now, the beauty of the applicant's affidavit, opposed to when it was, is that it's a contemporaneous note and recordal of various things. When he deposed to that affidavit, there is nothing to suggest that he had some inside knowledge of how long an airport keeps their CCTV footage. So when he challenges the state and says, I challenge you, show me the TV footage, I submit that some weight has to be attached to such a challenge. Now, in respect of the toll plaza coming from the airport, my learned friend has forgotten. If you drive from Verulam through and you join the N2, you go through that same toll plaza. It is not just restricted to the airport. And from Verulam, well, you can go various directions all over, really. So no, it doesn't. It's not a one-way road only from the airport to the toll plaza. That's wrong. Similarly, Your Worship, the statements that were found in the cubbyhole pertaining to the BMW. Now, I've submitted yesterday, I submit again. It's not interference. Applicant number 1 was never an arrested person at that stage. He was never a suspect for anything at that stage. But it is consistent with applicant number 4 saying and maintaining, I've done nothing wrong. I'm proactive. I'd like to answer the allegations. That's why My instructing attorney was sent to obtain the extradition papers. Let us see what they say so I can address it. I'm not going to shy away from what he said. I'm going to deal with it. And that's what he did. That's what any law-abiding citizen should do. Well, Your Worship, there's no... Yes. And they're not witnesses in this matter.
No, but they are witnesses in a case.
Yes, Your Worship, but at that stage, this applicant was not a suspect. He didn't know he was a suspect.
What business did he have with getting witness statement?
Once again, Your Worship, you want to clear up what has occurred. I notice Your Worship shaking your head.
Yeah, no, I'm really shaking my head
No, I
because
see
what
that.
you're saying now, really, I don't agree with respect.
And that's fine. I take Your Worship's point.
Yes.
Now, to touch on the cell phone, as my learned friend has said, we live in a digital age. What they don't take into account is you can have numerous virtual cards, same card, duplicate, identical cards, linked to various cell phones. You can have duplicate SIM cards. SIM cards can be swapped. So it's not clear-cut as the state would like to suggest. But in any event, that's not evidence before Your Worship, because it's not in the affidavit. Now, my learned friend has made mention of a possible public outcry to the applicants getting bail. It's one thing to say you can hear the noise of demonstrators or protesters outside court. But to suggest that if you go onto social media, you will find something to that effect. It is not clear to me whether the state is in fact saying to Your Worship that you, sir, need to go onto social media and you will see this. Because of course the state would know that that would be improper. So the end result is there is no evidence before Your Worship to demonstrate that the release of these applicants on bail would cause a public outcry. No evidence led. So, the last point, Your Worship, if I may, is the missing cell phone. My learned friend made mention of the fact that a case was opened at IPID and that the phone wasn't listed. What he has forgotten to mention to Your Worship was that it's the applicant's wife who opened the case, not him. But over and above that, how often does it occur that someone, for example, is the victim of a housebreaking and they give a statement to the police or to the insurer to say, these were the things that were taken. And sometime down the line they remember, oh yes, it's this and oh yes, it's that. So that would be my response in relation to those two aspects. I note my learned friend in argument did not address the chances of applicant number 4 absconding, and I take that as a concession. There's no evidence to suggest he would abscond if Your Worship should release him on bail. There is no evidence that he would interfere with witnesses, tamper with evidence, and there's no evidence of a public outcry. So in conclusion, Your Worship, applicant number 4 has gone the extra mile to address in his founding affidavit what the state will say the case against him is, by obtaining the papers in the extradition, as well as just addressing what he saw on the media. So, Your Worship, my closing submission would be he has discharged the onus. It is in the interest of justice that he be released on bail with appropriate conditions and in an appropriate sum, as Your Worship should see fit. As Your Worship pleases.
At the inception of the proceedings, we agreed on dates, and some of the dates were honored and some of the dates were not honored. I would have loved to give judgment before the 15th, but unfortunately, I'm away the whole of next week. I'm out of office and I cannot even venture coming to this side. So I propose that we stick to the original date, which is the 15th, the date that we all agreed upon. Do we still confirm the date as the 15th?
I will not be personally present. I think we did agree on that date that my candidate attorney may be present, no judgment. Unless there is a possibility that I might have to address court, then the date will not be suitable. I think at the time I did mention that I'm going to trial in Tebello. So then my candidate attorney can note judgment, but if there is a possibility, then the date will not be suitable. I did put it in my diary and it is confirmed.
Okay, thank you.
Thank you, Worship.
You want to say something?
I can only confirm if it's the 15th of May.
15th of May.
Thank you, Worship.
Thank you, Mr. Chair. Yes, it's the 15th of May.
Yeah, that's a
Week after next. Applicant may rise. Gentlemen, the matter against you is then postponed for judgment until the 15th of May. On that day, I'm sure I'll be able to pronounce myself on the issue of bail. Do we have the court book here? Thank you. You may stand. Thank you. Yesterday. When is the announcement?
The matter which is postponed involving 3 others. Some few weeks ago, we were informed, myself, Ms. Gilling and Mr. Volmarans are involved in that matter. The other bail application. We were informed yesterday that it appears the J7s were not signed or something to that effect. And the matter is coming next week on Tuesday the 7th. What we now requested is that we make requisitions so that we don't find ourselves on the 7th without any accused being present.
Requisition for when?
For the 7th, Your Worship.
Oh, okay.
So the charge sheet is here. Your Worship postponed the matter for us on the 27th of March to the 7th of May.
Okay.
But now the accused are saying they don't have the J7s in prison for the 7th of May. So we're thinking not to find ourselves.
If the charge sheet is here and it's
Yes,
my
yes,
handwriting, I'm prepared to sign the
Yes,
case.
Worship. I've signed the requisition as well. Mr. Worship.
Worship, I have a copy of the charge sheet. I can just run quickly to
Okay, bring that to me, Jesus.
That then becomes the role for the day.
Okay, thank you. I thank you all for your patience and commitment that we sat through lunch and only finish now. That gives us the remainder of the afternoon to ourselves. Corrections until 15 May.
I'm not taking anything.
Okay, folks, I think all good job.